My lord, restoration in application for inclusion before your lord. Great. My lord.
Yes. Item number? It is in the today's list. It will be taken up today. Why are you mentioning this? Today. It will be taken up today. Yes.
May I have your lordship's kindly to mention, my lord, under
Today is not day of
I
mention.
understand, my lord, I know, but that, my lord, yesterday I missed my chance because of our enormous traffic with regard to the, my lord, the practice session at Red Road. My lord, I missed my chance, my lord. I was humbly beseeching your lordship, my lord, if this matter is not taken up any day, next week also, my lord, my right in the writ petition will be prejudiced because the license will be issued, my lord, if they have been selected, private respondent has been selected, my lord, on a agricultural land when there is nothing of any sort with regard to any conversion made by
Item number?
Item number 170. I have put the respondent on the notice, my lord. My lord, it is Dasharat Kumar. Item number 170 of your lordships. Any day convenient to your lordships, my lord, kindly have it upgraded, my lord. Otherwise, my lord, my entire writ petition will be prejudiced. 170 of days.
Release.
Today I shall start the list from 35.
My lord, I understand, my lord. Any day, my lord, convenient to your lordship. Next week also, my lord, because by this month, my lord, the entire thing will be completed, my lord. The entire writ application will be, my lord, infructuous.
35
170.
170. Dasharat Kumar. Or may I hand over the slip, my lord? It's on notice.
Next week. On mentioning, this matter be appeared under heading mention matter on 19th of
35.
So very good. Lord, I
Yes,
tender my
call the
apology
list.
for, my lord.
My lord, may I be permitted
My lord,
to mention,
may I-
my lord, this one matter, my lord, under extreme urgency, my lord.
All urgent matter.
My lord, this is my lord.
All
My lord, this is my lord.
urgent matter.
This matter, my lord, is really.
No urgent matter.
My lord, may I just, my lord, indicate the urgency, my lord. My lord, order 22.
What is the list?
My lord, list is, my lord, this is item number 53 of the day's list.
Then it will be taken up today.
My
What
lord,
you are mentioning?
my lord, the urgency, my lord.
I start the list from 35 today.
My lord, my lord, if it is not,
Follow the list.
my lord, may I only indicate one thing, my lord?
Let me start the matter today. Yes.
My lord, same, my lord. I have a signed matter in my lord's list, item number 51, my lord. It
It
is
will be taken
running
up
just,
today.
my lord.
My lord, for
I'll wait, my lord.
my lord has given the liberty to mention, my lord. The time has already been over, lordship. Kindly for inclusion only. Lordship, order is annexed with my mentioning slip, lordship.
Lordship, may I be permitted item number 226. Lordship, next week, my lord, mention matter vacancy notice 2013 control order 226.
226.
Yes, lordship.
Last matter. Last part one matter.
Yes, lordship.
What you want? Upgradation.
Only lordship next week mention matter actually 2013 control order vacancy notice.
To come tomorrow. Let's see how far I can go.
Yes.
Okay.
Get.
Yes. Call the list.
LPG distributors covered by your lordship's order. I'm handing over. Restructure policy, transfer of customers relying on the circular dated 21st February. Pair GNH, also pair GNH and paying for. The circular has been stayed and the transfer order also has been stayed by your lordship, which will appear from page 15, paragraph 27. My learned friend has appeared in that matter also.
Similar matter.
My lord, these are all, as my learned senior friend is submitting, my lord, these are all on the basis of that circular of 2025 also, my lord.
Okay.
And, but my lord, may I respectfully submit a small correction, just a very minor. I have talked with my learned senior friend, my lord. It's at paragraph 24, if my lord kindly takes.
Paragraph 24 of writ petition.
No, my lord. My lord, paragraph 24 of my lord's
Page
order, my
13.
lord.
Order.
Yes, my lord.
13.
My lord, and in today's writ petition, my lord, the first writ petition is WPA 16694 of 2025. It's Nilima Paul. If my lord kindly takes, my lord, page 61, my lord.
Yes.
And if my lord kindly keeps, my lord, my lord's order, my lord, paragraph 24, my lord. My lord, the last portion of the paragraph 24, if my lord, may I, with my lord's kind leave, my lord, read the sentence, my lord. There are clauses in the earlier circular, if my lord has seen, my lord. My lord, paragraph.
There are clauses in the earlier circular.
Yes, my lord. There are clauses in the earlier circular that distributors may retain 75% of the refill ceiling limit applicable to them. In the present circular, each distributor was directed to retain 100% of their refill ceiling limit.
Yes.
At the same time, the refill ceiling limit per month and viability limits of all distributors have been reduced. My lord, this is particularly, my lord, is having some objection to this particular observation of my lord, because of the fact, if my lord kindly sees at page 61 of the writ petition, my lord,
Yes.
the refill ceiling limits were initially, when in the 2018 circular, which was the earlier circular, it was 16,500, thereafter 13,200, thereafter 11,000, and thereafter, my lord, 8,800.
Yes.
Thereafter, my lord, in the 2025 circular, if my lord in the kindly takes, my lord, at page 150, my lord, which my learned senior friends writ petition, my lord, he has annexed, my lord.
150.
My lord.
Yes.
My lord will kindly takes the chart, my lord, which according to the circular, my lord, the refill ceiling limit per month is 20,000, which is enhanced, my lord. Thereafter, towns with 20 lakhs to 40 lakhs population, my lord, is 15,000. Thereafter, towns with 10 lakhs to 20 lakhs population is 12,000. So, my lord, there's a gradual increase in this particular refill ceiling limit. My lord, I have no objections regarding the interim order which my lord has passed in those writ petitions, but my lord, this particular chart has to be construed according to what it is. It is
Okay.
my respectful, deepest submission. I have talked with my learned senior friend on this, my lord. My lord, since my lord is
Not reduced.
yes, my lord. That is what, my lord. It's the specific instructions of the ministry, my lord, also of the oil marketing companies, others also, BPCL and IOCL, that it has not been reduced.
Okay.
So, my lord, that observation I have having some reservations. Otherwise, my lord, may I respect, my lord? Otherwise, my lord, senior friends, my lord. So that has to be recasted a bit, my lord.
Only this paragraph.
Yes, my lord. At the same time, the refill ceiling limit per month of average limits of distributors has been reduced. My lord, this has to be, my lord. This cannot.
Has not been reduced.
Yes, my lord. That has been increased, my lord. That has been increased. If my lord,
Increased, kindly record it has not been reduced.
my lord, with the leverage of my lord, senior friend, my lord, I can humbly pray, my lord, that it has not been reduced, my lord. It has been increased, and my lord, not been reduced or increased, my lord.
Okay.
Concern, there will be some argument from my behalf also. My lord.
But my lord, my learned friend is enjoying an interim order of all the writ petitions.
It has been
Yes.
increased, that will be the.
My lord, my lord, it has been increased. My lord will kindly seize, my lord. 20,000, 16,500.
I have.
Yes, my lord. 13,200. Thereafter 15,000. My lord, all has been increased. My lord, this is on the face of it. I am not relying on anything which is beyond the document. And in my lord's judgments, my lord, the earlier division bench's orders, my lord has observed on basis of that, my lord has interfered in the writ petition. So, my lord, this circular prima facie does not have any prejudiciary effects to the distributors. But what is that, my lord? This has been increased. This has not been reduced, my lord.
Okay.
This is my deepest respectful submission before my lord. With my learned senior friends, leave, my lord.
Paragraph, your lordship may delete that paragraph also. May. If this paragraph is deleted, nothing will be happen possibly. Paragraph 24, তুই যেটা
ওই
দেখাচ্ছিস।
24 এর লাস্ট সেন্টেন্স গুলো তো
না, পুরোটাই
না পুরোটা যদি আবার হয়ে যায় তাহলে মুশকিল হয়ে যাবে না
কেন মুশকিল হবে? তো সবকিছুই মুশকিল।
না এটা তোমারই তো ফেভার লিখে earlier policy which was under challenge before this honorable court and was decided finally by the order of the honorable division bench. There are clauses in the earlier circular that the distribution may retain 75%, there are 100%. এটা তো ঠিক আছে my lord, till 100% of the ceiling limit is okay, my lord.
Yes.
Thereafter, my lord, at the same time, my lord, that particular sentence is subject to my lord's kind consideration, my lord, can be removed.
Otherwise, same order can be passed.
My lord.
Malad, thereafter, there's another word which is reduced in the last sentence. If Malad kindly observes, 100% ceiling limit of them, that means actual refill ceiling limit, which was earlier with all the distributors, reduced by the strength of the circle. But this has, Malad, this is 1 second. This term, word reduced, Malad, is Malad not proper in this particular sentence, Malad. This can be just done away with subject to my lord's kind consideration.
It's not appeal.
No, no, yes.
My observation is on the basis of the
Absolutely,
earlier
my lord. Ultimate, what is going on?
paragraph 25, 26.
If it is
which are-
changed, my lord, that will create also difficulties, my lord, as I
But
understood.
my lord, that is not reduced, my lord. That is what my respect is for. This is a separate writ petition, my lord. That is why I'm humbly praying before my lord. And I have just talked with my learned senior friend also, my lord. That is the reason why I have mentioned this matter
Ultimately, it has
specifically.
been reduced.
No, my lord, that is not reduced. That is my specific instructions.
Not
That's-
comparing,
No, no,
not
no.
comparing with the previous one. I am saying that you are
No, my lord is comparing in his my lord's order, my lord. That is the reason why I'm before my lord today. Because it has not been reduced, my lord. Refill ceiling limit per month has all been increased. 16,000, that has been 20,000, my lord.
percentage.
Okay. Please take down. I'm just rewriting the paragraph 24 only. Paragraph 26 টা change করে দিচ্ছি। Paragraph 24. 24. Okay, সব একই।
এটা তো তোমারই ফেভার আছে ইভেন এটা কাট দিবেন তাহলে পলিসি ইউজ করে আমরা চ্যানেল আছে না তার কাইন্ডলি সেখানে কাটা উচিত না
Paragraph 24. Having heard the long submissions of the respective parties and also considering the observation of the Honorable Apex Court, it appears that much have been argued by the parties in respect of the present impugned policy circular dated 21st of February 2025 of the three oil marketing companies. Full stop. The earlier policy, which was under challenge before this court and was decided finally by the Honorable Division Bench, there are clauses in the earlier circular that distributor may retain 75% of refill ceiling limit applicable to them. Full stop. In the present circular, each distributor was directed to retain 100% of their ceiling limit. Full stop. To the refill ceiling limit per month and viability limits of the all distributors has not been reduced, but the purpose of the three oil marketing company by the strength of the impugned marketing structure policy has itself make it clear that they intend to distribute customers from one LPG distributor to another distributor. Full stop.
This is actually old distributor to the newly appointed distributor.
সেটাই বলেছি।
Distributor কেন?
And my lord will kindly observe my submission, my lord, that I have submitted that this particular chart as my lord can incorporate in any portion of my lord's order, my lord. That it was the submission of the oil marketing company that the refill ceiling limits have been increased.
What was the earlier which was under challenge?
My lord, that was
Page 61.
Page 61. No, page 61 is the 2018,
yes, my lord.
which was struck down.
Yes,
What was
this
the-
one struck down. This page 61 has been struck down by the Bombay High Court Division Bench.
page 61?
My
Okay, okay. Thank you, বললাম। না লাস্টে বললাম, বলো। Policy from old LPG distributor, LPG distributor to new LPG distributor. Full stop. Paragraph 25 same হবে। টোয়েন্টি সেম হবে, 27 সেম হবে। প্যারাগ্রাফ 21 এর লাস্টে অ্যাড করব, লাস্টে অ্যাড করব। 21 দেখতে পাচ্ছ না? হ্যাঁ, এই তো প্যারাগ্রাফ 20। It is further contention of the learned counsel for the oil marketing company that refill ceiling limit of the distributors in earlier notification dated January 9, 2018 has been enhanced by the present notification. So the petitioner should not be aggrieved by the new notification. Should not be aggrieved by the new market restructuring policy of the three oil marketing companies. এটা add করতে। Same interim order.
PRGNH.
Yes.
এখানে কোনো ইমেল কমিউনিকেশন তো আছে না? Distributor has to be returned.
Their GNH.
My lord. At page my lord 33.
1, 2, 3 same order.
1, 2, 3 same order. All GNH.
ঠিক আছে। Affidavit of service filed on
Affidavit service করে দিল।
Deeply obliged, my lord.
In terms of PRGNH.
Call the list.
The affidavit service may be filed, my lord.
Same.
Or affidavit service file may be kept on record.
My lord has observed it has not been reduced, my lord. Deeply obliged.
Okay. Thank you.
As I have taken already the earlier view, so I cannot,
Absolutely.
because of the fact that division bench has already approved this view. So I cannot pass any separate order.
No, my lord, this refill ceiling limits has not been reduced.
Yes.
That is what, my lord. Other than that, I am not at all, my lord, praying, my lord, for any variation of that particular order, my lord.
Very.
Or
Yes.
affidavit service file may be kept on record.
Item number 3.
3 separate orders.
Similar order.
3 separate orders.
Call the list.
Also, in this matter, Mr. Putit Chatterjee, appearing for the bid, he is coming, he is starting, but although he has already completed yet submission.
No,
Then-
35. In this matter, learned AG
Learned
is
AG
because the virus is challenged in this matter, your lordship.
Yes,
Do you have any instruction from the AG office?
we have appeared before your lordship yesterday. So from the AG office, somebody was appearing and they said that we have
No,
filed the affidavit.
nobody was appearing on behalf
Yes,
of.
yes,
No,
they-
my junior was there.
Yes, yes. They said that there is.
Yes, we have informed. We have informed. Again, I will inform. Somebody, I'm expecting that either Mr. Sanya Bandyopadhyay, most likely, I think I will have a word with him and I will apprise your lordship with respect to that.
Okay.
আমি জিজ্ঞেস করে
Let it be pass it over.
Yes, pass.
My lord, I have some other matters. If it is not possible to me, lordship kindly pardon me.
There must have some representative of learned AG, otherwise we cannot proceed, you understand?
Virus has been challenged. Huh?
But this is the third day, my lord.
I know AG is very busy, you know, the matter has been fixed today. That's why I'm passing it over today. Just pass it over.
If I fail to appear, lordship kindly
আমি
confirm my
আপনার
appearance.
behalf এ submission করে দেবো
Okay,
হয়ে গেল
If possible, I will come.
Today, tomorrow.
If possible, I will come.
Okay.
and if in case he doesn't come I will
All lordships kindly fix at 12 p.m. or any time that I will.
No.
no, don't fix any time.
This is
They
the
are-
first matter, mention matter, first matter. I put it.
I will-
And
First matter.
I am ready. Yesterday also I was ready.
I will inform the AG's office, lordship. I will come back. Oh, তুমি বলেছো? You have informed? Informed. Yeah. भेज भी चुके हो. What did they say?
So can you start today?
No, he is with me, your lordship.
Okay.
Okay, we are representing the state,
Okay,
but
okay.
since virus is
Okay,
challenged,
pass it over. Pass it
yes, I will definitely apprise your lordship.
আমাকে ফোন করো শোনা
বলুন।
ফোন করে যদি আসে
আমি দেখে নিচ্ছি আর
Next.
আপনি নিশ্চিন্ত থাকুন আপনি যদি নাও থাকেন আমি ওপেন কোর্টে সাবমিশন করছি আমি বলে দেবো
36. No one is there. Not today. Next.
37 না তো
Yes, my lord, I appear on behalf of the state, my lord, but I am filing my report, my lord. But I have soft copy, my lord, already. The petition has been filed, my lord, by the petitioners. Since they are challenging the new vacancy, lord, alleging that their total ration card sum decreased, their right has been curtailed. And they have challenged the 2013 and 22 policy.
Okay, I understand. The same
Let
matter.
them file, or my lord has passed similar order in another matter.
26th, I fix the matter.
26.
All the matter. 26. Please take down. Report in the form of affidavit. File on behalf of the state respondents be taken on record. Copy served.
Lordship,
Copy served. Petitioner is at leave to use exception stroke reply if any within a week. List the matter on 26th. Under the same heading. Next.
this is. Lordship, item number 37, Lordship. 26 তে fix হয়েছে, তোমরা exception file করো।
Report. No, affidavit in opposition.
we have already submitted the report to the department. It has not been vetted as yet. Kindly allows us some more time.
Who is for the petitioner?
Mr. Bakchi was appearing on the last date. Master Bakchi,
Devayan Ghosh?
Devayan Ghosh and Ms. Kriti Kar. I will inform them.
Okay. Ms. Sonal Sinha, learned AGP, appears on behalf of the state, who submits that the affidavit in opposition is not ready today, so he seeks some accommodation. Let the matter appear in the list. No. And the accommodation as sought for by the state respondent is allowed. The state respondent to file the affidavit in opposition within
ही करने वाला बहुत और हम लोग में अंडरस्टैंडिंग है तुम नहीं जाओगी तुम्हारा
1 week. Hence, list the matter on 27th of August.
27th last week to start.
Next.
Item number 14, Mr. Samuel Bari is appearing for the petition. He is now appearing in 749. And his clerk instructed me to take some part of it.
Not today.
It could be, not today, could be. Take it.
You are appearing
For the state.
Not today.
40.
40, not today.
not today. Next.
No, 14 I am for the petition, man. Yeah, please.
Yes.
There is matter relating to appointment of dealership. After my application was rejected by the DDPS and approved by the candidature of the respondent number 6, I submitted a representation before the DDPS at page 26. I only seeking for consideration that petition.
What is the matter?
Matter, my lord, a vacancy was declared. Inquiry was held. After inquiry was held, on the basis of report filed by the SCFS, director rejected my application and approved the candidature of the respondent number 6. Man. Before issuance of the license, I submitted a representation before the DDPS at page 26. Till date, their representation not yet considered, my lord.
What is the objection?
Objection, my lord, at page 5, paragraph 8.
Which for the state?
Lordship, I am for the respondent number 6, Lordship.
Private
License
respondent.
have been granted, Lordship. I am continuing my business.
No, my lord. He did not till date issue allotted EPOS machine.
Lordship,
Till date.
I have.
Paragraph
8, page 5. During pendency of the representation, license has been issued. I know, my lord. But till date, no EPOS machine was allotted in favor of the respondent number 6.
No, 615 is the Danga.
Yes, madam. I so prefer only consideration of my representation by the DDPS. Since license has been issued, madam, I cannot pay for interim
Lordship,
order.
license has been issued already. The distribution goods already allocated to me, Lordship.
You raised
I'm
this point. Whether you have heard?
No, my lord. Till date, representation not yet considered. At page 26.
This is your first representation.
First representation. Before issuance of the license, I made a representation. 30 June, my lord. I only seeking for consideration my representation. But my license has been
I appear for the private respondent, my lord.
Yes.
Mr. Dhar is only seeking for representation, my lord, then of course I cannot come in.
Please take down. petitioner applied for license in terms of vacancy notification dated 15th of May 2024 issued by SCFS Canning. It is the submission of the petitioner that private respondent was selected for granting license by the concerned authority. Full stop. It is the positive fact of the petitioner that the proposed shop cum go down of the private respondent is situated at Dag number 615, which is classified as Danga. Of its half portion is government land. He made a specific representation stroke objection to the authority concerned regarding the situation of regarding the proposed shop cum go down of private respondent. His representation was not considered. Hence this writ. Despite affidavit of service filed on behalf of the petitioner be taken on record, despite service done appears on behalf of the state respondent. Mr. Huda, learned counsel, appears on behalf of private respondent. It appears that the petitioner has raised some objection regarding proposed shop cum go down of the private respondent. It is the contention of the petitioner that half portion of plot number 615, which showed by the private respondent to be proposed shop cum go down, is over common land. Full stop. It appears that the allegation against the private respondent is serious in nature. The respondent authority must consider the representation filed by the placed by the petitioner on 30th of June 2025 within bracket annexure P5. Under the above observation, the instant writ petition is disposed of. Director DDPS Food and Supply Department, Government of West Bengal, being respondent number?
Number 3, my lord.
Respondent number 3 of the instant writ petition is hereby directed to
No, my lord, it's not 2, my lord.
respondent number 2 directed to consider the representation of the petitioner dated 30th of June 2025 within bracket annexure P5 of the writ petition bracket 2. After giving a reasonable opportunity of being heard to the petitioner within 6 weeks from the date of communication of the short. Full stop. The decision of the concerned director DDPS shall be communicated to the petitioner within 2 weeks thereafter. Full stop. I make it clear that this court has not entered into the merit of this matter. The concerned respondent number 2 shall dispose of the representation according to law without being influenced by any observation of this court.
My lord.
Since no affidavit has been exchanged between the parties, allegation made in the writ petition shall be deemed to have been not admitted.
A diploma.
Right, my lord. Just one thing, my lord. Just one thing, my lord. Where lordship had, my lord, has observed, my lord, that Mr. Huda appears for the private respondent. Kindly, my lord, adds it and refutes the allegation of the petitioner, my lord. Because this is absolutely incorrect, my lord. Not on government land. Both land are mine, and it's on 614.
What's the contention of the petition?
Deeply blind. And my lord, perhaps, my lord, the direction would be on the district controller, my lord, and not on the director, my lord. Because in other cases,
Approval authority, district director.
no, approval authority, licensing authority is always, my lord, the sub.
Very well. Okay. Next.
Obliged.
And I beg to appear on behalf of the petitioner, my lord. The petitioner had applied for an FPS license. He had all the qualifications to do so, my lord. I'll just 42.
Yeah.
The notification is at page 17, my lord.
Yes.
And I satisfy all the minimum qualifications. But despite the same, my lord, I have been rejected for without citing any reason. The rejection is at page 64.
What is your prayer in the writ petition?
And for quashing the appointment of the
For quashing?
private respondent, and for selecting me, my lord.
Why?
I've
Does the
stated.
ground?
Will kindly come to page 8, my lord. I'll show for my pleadings, my lord. Paragraph 17 and paragraph 18, my lord. The respondent authorities did not give any reasons as to why the application of the petitioner was not.
There should not be. There are no provision to give you reason. There are no provision in the control order to
But
give you
in my humble submission, my
Have
lord,
you submitted any representation?
my lord. My lord.
Have you submitted any representation?
But it is not maintainable because he has submitted some false and forged documents on the basis of
Forged
that.
documents. Now this is
Let me understand. Yes.
the representation.
You did not file any representation.
My representation has not been filed, but if my lord directs, I'll file a representation. My that my.
What is the other grounds?
But
Challenge.
But the ground of challenge is that when it comes to my infrastructure, I have a superior infrastructure than that of the private respondent. But in spite of that, the private respondent has been selected and the petitioner has not been selected.
Yes,
I have disclosed all my infrastructural documents, my lord, all my eligibility documents. When it comes to the private respondent's documents, I cannot have that in my possession, my lord. But I have there is a specific pleading in that regard, my lord, paragraph 18, my lord.
Read out.
My lord. Your petitioner states that the private respondent was a pre-selected candidate who was unduly favored by the respondent authorities in gross violation of the principles of transparency, fairness, and equal opportunity. It is submitted that the selection process was vitiated by arbitrariness and malafide intent, as is evident from the fact that no reasoned order was passed explaining why the application of the petitioner was rejected, despite the petitioner fulfilling all eligibility criteria and possessing superior infrastructure. The petitioner had at his disposal 2 go-down spaces of 265 square feet and 600 square feet respectively, an office space of 200 square feet and a shed covered area of 76 square feet, which clearly surpasses the infrastructure requirement stipulated in the notification dated 1st September 2023 and is far superior to the infrastructure purportedly offered by the private respondent. Moreover, the verification report confirms that the petitioner's location was more accessible and would have been more beneficial to the local populace. Despite these factors, the respondent authorities did not provide any cogent reasons for rejecting the petitioner's candidature and failed to disclose any comparative assessment or panel justifying the selection of the private respondent. Such conduct strongly indicates that the private respondent was favored from the inception of the process to the exclusion and prejudice of the petitioner. So this is my specific contention, that I have a superior infrastructure.
What is the infrastructure of the private respondent?
Nothing.
Have you stated this?
Private respondent, I can't have the papers.
Then
my
how
lord, of the
would you
private
say that
respondent.
you are the superior?
But since he has been
You should
selected,
have made a representation to the authority.
But
Why you
if-
straight coming to the court?
today
do not
he
know
has been
nothing
given
about
the
the
granted
private
the license.
infrastructure
He
of
is doing business in spite of having less infrastructure. He is doing
What are the
business.
less infrastructure? Have you stated
But
anything?
I can't have his
When
documents.
you are saying that I am the superior, I am the
But
superior, how?
because after his after he's selected, I can
It is something that by such the private respondent is inferior to you. Where is the pleading?
but the pleading is there that he has inferior.
You are the superior and he is inferior. How? Only by submitting that.
I will kindly come to page 62. This is my inspection details.
I understand this is your inspection details.
Let the state give a report that the private respondent has superior infrastructure and I'm out of court.
Why you directly come to this court, not proceed to the state respondent to know the entire matter?
Because the state
Whether you are denied, not denied, you have not proceeded.
My application has been rejected.
Why? Where?
My-
Where is your application?
My-
Your application was rejected. Your application for Vacancy notification.
Vacancy notification was,
It was rejected and intimated to you, it was rejected.
but that I can do, but my lord knows that my lord has the powers under Article 226 to call for a report. And
That's
if,
why I know, but I have to
because if I
satisfy.
even if I give a representation, my lord knows that they will, by hook and crook.
No, you give your representation.
No, I did not give a
Then-
representation.
Yes, you are for the private response.
No, I am for the state respondent.
State. Yes.
My lord, kindly see, my lord, the.
May be favored with a copy
My
of.
lord, my lord, kindly see, my lord, the second internal page, my lord. Apparently,
Second page,
yes, my lord, kindly see, my lord, the
read out.
apparently it seemed before the inquiry team that both the applicants fulfilled the eligibility criteria. Both the applicants mean applicant, petitioner and private respondent.
Okay.
And in terms of suitability of the storage go down, Spinoza Khatun was considered as the most suitable candidate and Allah Raka Sheikh was considered as the eligible but not found the most suitable candidate. However, on 6/5/2024, an application for cancellation for candidature of Allah Raka Sheikh was received by the office of the subdivisional controller, Verampur Sodor, for another applicant, Mohammad Farooq Hussain, along with the supporting document against his statement. Based on this application, the office of the subdivisional controller, Verampur Sodor, conducted an inquiry for verifying the genuineness of the medical fitness certificate submitted by the petitioner named Allah Raka Sheikh, having reference number such and such. The medical superintendent cum vice principal of the Murshidabad Medical College and Hospital, Verampur, Murshidabad certified his memo number such and such that such medical fitness certificate in respect of Allah Raka Sheikh was never issued from their hospital. And one
Anything remains, my lord, after that, anything remains.
Kindly see page
Forged
23.
document.
No, not forged
What
document.
things must be
These are-
initiated against you.
Knowing fully well that I have superior infrastructure, now these are coming.
Let him affirm an
no.
affidavit saying that this document is genuine one first.
Yes, I've annexed all these documents to the
And
petition.
Let him proceed.
My lord, kindly see page 23, my lord. The certificate, my lord, of the medical superintendent cum vice principal Murshidabad, that in connection with your letter number such and such, the medical certificate in respect of Allah Raka Sheikh is not issued from this office.
Where is the medical certificate?
That is, my lord, page 21.
Kindly come to page 37 of the petition. He has also annexed it. Forged.
No, not
document.
not forged. Not forged. Today, the state and the private respondents are colluding with
Yes,
each
that's
other
right.
for this.
Yes. This
Yes.
is the issue.
Yes, my lord, on that ground, my lord, this, my lord, application, my lord, of the petitioner has been, my lord, rejected. It has been rejected. So, my lord, question of filing representation, my lord, will not, my lord,
Serve the purpose.
serve the purpose, my lord, because, my lord, already, my lord, rejected on that ground.
It's very convenient for the state to state that something is forged and reject my application when I have a.
Not easy for the state. The
But
state
the
authority
state
has to
is-
take responsibility before
So
the court.
let them
Yes.
let them take responsibility and let
Otherwise,
them
you have
file
to
this
take
by
the
way of an affidavit.
The frozen document.
Let them file this by way of an affidavit, and I'll take out a perjury
Very
application.
easy for a public to say this is a not forged, not a forged, but a government person
Not
cannot
a
say like
this
that.
is signed by a government official.
Yes, that's
Page
right.
37, this is signed by a government official. These are the seal of a government official. Have they filed a FIR against me? If it's on the ground that this is a forged document. Today, after the litigation is filed, this is nothing but a product of afterthought. Has any FIR, has any police complaint been filed against me for this?
Very good.
Let the medical officer maybe add as the party respondent and he shall file an affidavit so that the proceedings may be initiated against the petitioner for submission of the forged and manufactured documents.
I'll file a
Still
perjury
accepted.
application as well, and when it comes to the private respondent, so his license should be stayed in the meantime. In that case, if he does not have the infrastructure that I have,
Peter Mala, my license will cancel today, and it may be granted to my land and fence client. On consider.
if I have a superior infrastructure, I should be granted a license. Today, what is forged? My lord will kindly see what is forged according to the state and the private respondent. And the private respondent, even before the state submitted the report, the private respondent knows that this is forged, and the submissions were made to that effect. So my lord understands what is happening.
Yes.
There must be a direction upon the police authorities or the hospital authority to initiate proceedings against my land and fence client.
It has not been initiated, and this is a
hospital
product of afterthought. This has not been initiated till date, for which it becomes evident that this is
That's the consequence.
yes, I go no, this is something. This is nothing but a product of afterthought. Why has not this not been initiated against me at the time I submitted this? If this is the case, and this is the reason for my rejection,
Appropriate proceedings must be initiated. That's my
appropriate process. Let them file this by way of an affidavit. I'll take up our perjury application as well. And the private respondent also needs to understand that everything cannot be done by colluding with the state. Somebody with an inferior infrastructure having a distance of having more distance from the central point is being given a candidature, and when I challenge
I'll
this,
look into the matter. No issue. Please take down. Petitioner challenge selection of private respondent in as a MR dealer in terms of vacancy notification dated 1st of September 2023 issued by SCFS Bahrampur. Full stop. It is the contention of the petitioner that he has the better infrastructure and most suitable candidate to get the license, but to have the license, but the respondent authority has malafidely and purposefully selected private respondent. Full stop.
my affidavit of service may be taken on.
Affidavit of service file. State authority place brief case history of the impugn notification, wherein they have specifically stated that the candidature of the petitioner was cancelled as he have placed a medical document purported to be signed by Superintendent cum Vice Principal Murshidabad, which is a forged one. The report of the Vice Principal of Murshidabad Medical College and Hospital is placed with the said statement. The petitioner submits that he has never forged any document. This is prepared for the purpose to defraud the claim of the petitioner. Having heard the learned counsel for the parties, it appears to be appropriate to direct the state authority to file a affidavit in opposition against the writ petition.
But may it be a report, my lord, otherwise it goes into the
No, affidavit, I want affidavit.
But affidavit in the report in the form of an affidavit.
No, affidavit, I
Well,
want
because I
affidavit
do
in
not.
opposition. No. This, if you are raising so objection, I want the affidavit. Affidavit in opposition against the writ petition. Let the affidavit be placed on record within 3 weeks. Within 3 weeks. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. As the allegation made in the statement by the statement of the state respondent, it's serious in nature. I direct the petitioner to incorporate Superintendent and Vice Principal of Murshidabad Medical College and Hospital, Behrampur, District Murshidabad, to be a party respondent in the instant proceeding. Full stop. The petitioner is further directed to serve upon the added respondent in respect of writ petition and annexures thereof, and file an affidavit of service on the returnable date. Let the matter appear in the list on 22nd of September 2025.
So if it can retain its position, madam, that's my only humble submission.
What? It's a hearing matter.
My hearing matter, but let it retain its position, my lord, because otherwise
There
the
must
private
be
risk.
formalities, affidavit in opposition, reply.
I bow down to your lordship, but if I have a superior infrastructure and if I am depressed, if
his
the
client first.
say what will I save the client? This allegation has come after I filed
A
the writ
specific
petition.
date, otherwise I could not fix a date. I have fixed a specific, it will appear on that date. Next,
If a time can be fixed, my subject to your lordships.
I have all urgent matters.
I'm for the petitioner.
Your Lordship, I am appearing.
In item number 43, Lordship, I wish to be added as a party respondent in this matter, Lordship. In the same vacancy, Lordship, we have preferred another read where I am the petitioner. That is item number 46 of the today's list, Lordship. Can it be clubbed together? Can it be heard together, Lordship?
Absolutely not.
Item number 46, Lordship. I show to your Lordship that why we have preferred this writ application. I am a contesting candidate. According to me, I am the most eligible, Lordship. That is already it is in the list. Lordship.
Let's start.
Yes, your Lordship.
Let's start if Lordship will direct.
Lordship will take both these matter, item number 46 along with the item number 42.
Who is the petitioner in item 43? You
Is
were
the
the
petitioner?
petitioner.
Yes, your Lordship.
You
I
are
am
the-
I am in the same vacancy, Lordship. I am a contested candidate, Lordship. I also preferred and
You have filed the writ petition.
that is being item number 46 of the
Just wait, let me see, hear out the 43 first.
My
If
subject,
necessary, I'll hear.
pursuant to the vacancy notice issued by the concerned authority, will also kindly turn to page mile 10. This is dated 29th of May 2024. The location of the vacancy is Ghoshalpara, Raghunathpur, Konarpur, Paschim Mednipur. Have you also got my lord?
Yes.
I participated in the selection process. Following all the rules and regulations, kindly turn to page 14.
Yes.
Then kindly turn to page 17. My date of application I have shown to your lordship on page 14, 14th August 2024. Then kindly turn to page 17. Inquiry has been conducted. Kindly see the date of inquiry, January 2025 at page 17.
8th January 2025.
My lord. Then my lord, offer letter, hearing notice has been given by the district level sub-selection committee, page 18. Hearing has been taken place on 5th of May 2025 from bottom second paragraph.
Yes.
Then my lord, kindly see, my candidature has been approved on the next page on 14th August 2024.
Yes.
Approved. Then kindly turn to page 21. Offer letter has been issued.
Yes.
I deposited all the money. Kindly turn to page 2020. Next page, 35,000 as security money and license fee.
Yes.
When license has not been granted, I made a representation at page 24. Now, during pendency of the writ petition, license has been granted to me. I'm handing over the copy. Today, there is no interim order, no stay order, allotment has not been made, EPOS machine has not been issued. Kindly see the license.
So why you agreed?
Because my lord, allotment has not yet been made, EPOS machine has not been handed over. After filing the writ petition.
I want to intervene because I consider myself to be the most eligible person. Now they have been granted with the license. They have not given the allotment yet. My lord, we want to intervene. I can show from the documents. I want a liberty of your lordship to interfere in this matter.
One writ petition was filed, I think.
Item number 46 of
That will be
Yes,
taken
it
up,
was
that is
filed.
done.
it is there.
Then
So it can be taken up together, my lord.
No, absolutely
taken
not.
up after thereafter. Let me see what the state is saying.
So far my case is concerned, my lord, nothing is pending. only allotment and EPOS machine should be handed over to me.
Yes.
Mere pending of a writ petition filed by an unsuccessful candidate cannot stand on the way to issue EPOS machine and grant my lord allotment. This is my case so far my writ is concerned. Nothing wrong could be found.
Yes, what the state is saying?
Lordship, as per this up till here, I am with my learned friend that yes, offer letter has been issued.
License has been
Yes,
granted.
but after completion, I will just mention a few points which has come as instructions. On the 6th of Debuda, if I go wrong with the dates, you please correct me. On the 6th of May 2025, after completion of the hearing, the DLFP SCC committee had awarded the highest marks to Subhrata Ghosh, the petitioner herein, as he fulfilled all criteria and recommended him as the most eligible candidate for engagement as FPS dealer for the said vacancy. On the 14th of May, following all procedure, the Food and Supplies Department has approved as eligible candidate for FPS business in favor of Sri Subhrata Ghosh. Now, on the 15th of May, as per departmental guideline, the SCF&S Ghatal issued offer letter to the eligible candidate, Mr. Subhrata Ghosh. It is mentioned here that on that day, this undersigned office received a complaint from Sukanto Chanak, Sheikh Azizul Haq and Bushi Bari Ghosh, who are other applicants of the said vacancy, and they alleged that the godown of the selected candidate was situated in different Mauja and at a distance of 1.5 kilometers from the central location. 2. As selected person is the president of the cooperative societies, he cannot be an owner of FPS dealer. Now, this has come as an impediment, probably for not issuing the EPOs and allocation. Now, after that, Your Lordship, on the 23rd of May 2025, the DCF&S Paschim Mednipur has replied vide memo number 993 DCM WMR 2025 dated the 23rd of May that their complaint were not justified in accordance with vacancy native notification vide memo number this. Other applicants, Sukanta Chanak, Sheikh Azizul Haq, and Bushi Baro Ghosh have further lodged a complaint and said that according to the notification guidelines, the godown should be at least 1 feet height, but the person who was selected is much less than 1 feet height. The height of his godown has been wrongly shown as 2.5 feet. The height of our godown has been measured from the road, but the height of the godown of the person who was selected was not measured from the road on the front side. So the whole process is not transparent. After proper investigation, the right person will be selected. After the complaint on 27/5 today, on 28/5 2025, the complainant JCP planted soil in front of the godown. After receiving the complaint, an inquiry has been conducted by a team consisting of SCFS Ghatal and Sub-Inspector F&S Ghatal, and it was found that the plinth height from road level and ground level of the godown of Subhrata Ghosh are 9 inches and 3 feet 16 inches respectively. In addition to that, the said team measured the plinth height of the other present applicant on that day, and it was observed that in case of measurement of the plinth height by the previous inquiry team, the plinth height of the godown of all the applicant was taken from road level except Subhrata Ghosh, which was measured from ground level. This resulted in getting extra number over the other applicant in the selection process. In view of the above context, all the report had already been sent to the higher authority and instruction had been sought in this regard. This office is waiting for instruction from the higher authority for future course of action. Compliance of higher authority instruction is awaited. Though license was issued to Subhrata Ghosh. Now, this is the crux of the case that in a few pages is before Your Lordship that I have placed. So probably what my learned friend has now submitted, that it is only with respect to allocation and EPOS. This is the reason why at this point of time, though the license has been issued, I am not standing in way and I am not denying this. This is probably the reason this has not been
I
done.
don't think, my lord, for this reason, if any complaint is made and inquiry has been conducted
But
and found everything is fine, there is none of the allegation has been established. Rather, their candidature is not proper. Then after 23rd July, kindly see the date of the license. Bottom portion, date of issue 23rd July. There is no barrier to issue EPOS machine and make allotment today. It is not the case of the state also. So there should be a mandate upon the state that they should EPOS machine and the allotment.
I am not trying to make out
No,
any case. I have just submitted my only instruction leads to the inference that since the officers, everything has been placed on record and placed before the higher authorities, the decision has not been communicated to those who have issued the license. That is why EPOS and allocation has not been made. I'm just trying to make this submission. I have not made out any case. I have just gone by the instructions that has received and by the prayers of my learned friend, that is that the
Well, subject to
submission
lordship
has been
consideration,
made by
kindly
your
see the date of the license. That is after conducting inquiry on satisfaction. After conducting inquiry on the basis of the complaint lodged by the writ petitioner as well, sorry, my lord, my learned friend's client and the others, on satisfaction license has been granted. So today, my lord, issuance of people's machine and allotment is the automatic consequence.
But
I don't think, my lord, my learned friend has any say without filing any application for additional
right,
party.
right. But since I am not taking into consideration anything which is being submitted by Mr. Sabyasachi Chatterjee, who is praying for
Not at all a party.
as a party who has not been implemented as a party. But since there cannot be any denial that this complaint has already been mentioned in the instructions that I have submitted before your lordship, the department has already taken cognizance of the facts that have been brought maybe by him. He is in this matter, he is nobody. But not to forget that in this instructions, there is a mention of. So that is why I'm still saying that this is pending with the higher authority. I will not be in a position to say or state anything until I receive further instructions. Since he has already made his prayer, I have already placed my instructions. I can give a copy of it before your lordship. Lordship can also take it on record. After that, we have not denied him. Since there was a complaint, it has come in before us, and there's some things have been done. It's a practical difficulty which is faced by any office or any department. That is why we are quiet. And whether he be implemented as a party or whether I'm taking cognizance of that, he is nobody in this matter, and I'm not even saying anything. But since this has been mentioned by him in this instructions, I'm just bringing this to your lordship's kind attention. That is all.
Yes, Mr. Chatterjee, what is your complaint in the writ petition?
The complaint is
In the writ petition?
My lord, kindly take up my writ petition, my lord. I am seeking an inquiry against the officer who had inspected the premises of my learned friend's clients, which was shown as the godown. Now, there was a height problem. Now, it was pointed out to them, it was shown that by using the JCB, they were digging the mud from the road to show the plinth level has been matched. Now, this was done. Kindly come to my writ petition. Kindly come to item number 4.
My learned friend has no audience so far. My writ is concerned.
No,
this is my writ petition. No, there is no application.
I do agree. And my learned senior friend's client is a private respondent in that matter, in my writ petition. My lord, in my writ petition, page 70, there is a photograph with the geotag, and date is also given.
One matter is clear that the authority concerned has taken your application and complaint.
They have.
They are doing inquiries like that.
Now, whether they are inquiring,
that has been done,
And-
and on satisfaction license has been granted. Kindly take note of.
But since after granting of license, certain complaint has come up and many things have been indicated.
Maybe when you complain against the licensee has to be heard.
We have yet not decided. He's saying that it is still inconclusive.
Kindly see the date of inquiry and the date of license. That's my case.
That is still pending with the higher authority.
Then in that case, my lord, license may not have been granted to me. Had anything found wrong against mine.
should kindly consider.
The inquiry has been conducted, it was found, everything is okay. That's a report.
Page 69 of my writ petition.
Well, this petition is not being taken.
Has already been considered.
My lord,
Absolutely.
that has not been considered. I don't know what is the fate of this. I don't know the progress of the investigation or inquiry conducted by them. Now, I want the inquiry to be initiated because kindly come to page 69, my lord.
This writ petition is not being taken up.
Yes.
Why my learned friend is pleading?
It's item number 40.
There has no audience today.
But that has not fallen from lordship, that these two are being taken together at the very.
Not at all a party in
at
my
the very
petition. I have no grievance against him. He has not at all any right. Your lordship should be directed the authority concerned to make allotment and issue of the post machine. Because so far my writ is concerned, inquiry has been conducted, it was found everything right, then my license has been granted. Here, pendency of a writ petition filed by an unsuccessful candidate does not stands on the way to make allotment.
On contrary, my allegation is that during the inquiry,
Yes, the audience.
there was the corruption, there was other extraneous consideration which were considered by them, and they allotted this.
His writ petition, your lordship, may
And I
direct
give
the
the
report of the inquiry in his writ petition. Let him know it, and if he desires, he can file a fresh writ petition after going through the report. Because that has already been taken note of by the authority concerned.
Just kindly see paragraph 11 of my instruction. This is the most vital point, your lordship.
Absolutely.
Paragraph 11.
Yes, I have handed over a bunch of papers. Just see paragraph 11. Bolchi, porchi.
Everything is in my favor. They will going on making complaints, and I will be restrained to run my license after deposition of the security fees, license fees, everything. Possibly it is not the law.
Okay.
My lord.
So this is my instruction. I have submitted before your lordship that this, I don't know, I call it a mistake or inadvertence or carelessness. I do not know which word to pick, but last few lines go on to indicate that in addition to that, the said team measured the plinth height of the other present applicant on that day, and it was observed that in case of measurement of the plinth height by the previous inquiry team, the plinth height of the go down of all the applicant was taken from road level except of Subrato Ghosh, which was measured from ground level. This resulted in getting extra number over the other
Take note of
applicant.
this.
Yes.
What remains?
I'm submitting, I've handed over a bunch of documents. Whatever is, you cannot judge like this. মুখতে আসলো যে শব্দ ওটা বলে দিলাম।
Okay, please take down. Petitioner applied for license in terms of vacancy notification dated. In terms of notification dated 29th of May 2024, issued by SCFS Ghata. After complying with due formalities according to the
Well, may I come back?
control order.
Well, may I come back?
Control order, the concerned authority has issued offer letter in favor of the petitioner. Petitioner has deposited required fees to each alone to the department. Thereafter, a license was issued in favor of the petitioner on July 23rd, 2025. It is the contention of the, it is the grievance of the petitioner that after the issuance of such license, the concerned authority has not made any allotment, in favor of the petitioner. By such, he could not perform the business. He could not perform. He could not continue the he could not start the business, though the license has already been granted. Petitioner seeks necessary mandamus upon the authority so that petitioner may start the business in terms of the vacancy notification. Ms. Sonal Sinha, learned AGP, appearing on behalf of the petitioners, placed on record a case history of the incident matter. The case history reflects বলে এখান থেকে next para করো। This also pointed out the reply in para 11. Reply against para 11 of the writ petition, which is written as follows. Paragraph 11. It is the contention of the state authority that though the license has been granted in favor of the petitioner, but due to the inquiry conducted by the team, the entire matter was placed before the higher authority for necessary instruction. Till the instruction be received, the concerned authority had to take silence in this matter. That is the reason the allotment was not issued in favor of the petitioner. Having heard the learned counsel for the parties, also considering the grievance of the writ petitioners, it is true that license has been issued in terms of the notification in favor of the petitioner. Petitioner has deposited the entire cost, entire requisite fees to run the license from the statement, from the history as placed by the concerned department. It appears that the petitioner's business was stalled due to some complaint. However, the entire inquiry has been done. The matter has been placed before the higher authority. The department should take appropriate steps promptly so that the petitioner may run the business. Under the above objection, the writ petition is disposed of, directing the authority concerned to take a prompt decision on in this matter, most preferably within 2 weeks from the date of passing of this law. Accordingly, the writ petition is disposed of. The case history and parallel statement placed by the respondent authority be kept in the record. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not. Next, disposed of.
Lord, I am for the petition. First of all, Lord, I took leave to file a supplementary affidavit. 2 documents have not been annexed in the writ petition. Therefore, only 2 documents I have annexed in this. This leave may be granted to file it.
You have to serve it.
No, Lord, service is the very. Lord, I have filed it 1st August. Lord, suppose, Lord, I written a letter that I will move it on 3rd. But we received the F number, not final number. First. Second, when it is received my final number, I sent it the letter. And the next date she will not be receive this copy as until and unless court has directed to serve notice. In the presentation form, I written
Have you
it up.
served the writ petition?
No, my lord, they have not taken. Twice I have sent, my lord, they have not taken. Until a order be passed by the court, they serve the copy, then it will be taken.
What copy is?
The service copy. গন্ডগোল হয়ে গেছে। In the presentation form, I have said.
You are saying about the supplementary affidavit?
A supplementary affidavit be kept live, and also your lordship direct me to serve copy upon the state below I shall sir.
Very well.
And matter to taken up on Monday.
Monday? This Monday?
This Monday. Well, then 48 hours already.
Today is the one stage.
This is the listed motion.
Okay. Please take down. Supplementary affidavit filed on behalf of the petitioner be taken on record. Petitioner is directed to serve the supplementary affidavit, serve the writ petition along with the supplementary affidavit and annexes thereof upon the respondent authority and file an affidavit of service on the written date. Let the matter appear in the list. Let the motion matter on 18th of August 2020. Next.
So
I appear for the state now.
for the respondent number 7, it's all about the salt.
You are for the petition?
That's true, my lord.
Railways.
For the respondent number 7, my lord.
Okay. So what is the issue here?
Yes. Now, my lord, thanks to my friend, Mr. Ram, my lord, he is kind enough to prepare a very short note. I'm really, after reading that, that's a very nice. Whenever he'll help appear with me, always people are like this. দাও তো ভাই ওইটা আছে ওইটা করো তোমায় দিচ্ছি দাও হবে নিধন
Yes.
We are discussing about the salt. বেশি হলেও বিপদ না থাকলেও বিপদ বলেই তো বেশি হলেও বিপদ না হলেও বিপদ
Would be appropriate.
That's nothing. Kindly have a look. This salt is a central subject as appears in 8057 schedule of the Constitution and also an essential commodity to be monitored by the Department of Consumer Affairs. Naturally, my lord, is a central subject. The government of India banned sale of non-adhesive because, my lord, non-adhesive is a dangerous thing.
Yes.
In Bengal, it is called HON'BLE.
Yes.
Nowadays, it is gone, my lord, but that was a very painful, my lord. Iodized, if it is iodized, no problem. If it is not iodized, there's every risk. So government has a policy of the government without table salt must be iodized salt. The government of India bans sale of non-iodized salt and mandatorily requires the salt to be iodized before the sale for human consumption. According to the Bureau of Indian Standard, the contents of iodine in salt should be 20 to 30 ppm parts per million on dry weight basis at the manufacturing level and 15 to 30 on distribution channel. Well, this is very relevant because for obvious reasons, after research, they found this is a normal thing. If it is done, there is no problem.
Yes.
And kindly marked it, my lord. Dry wet. That is a vital aspect. So if it is not dry, there may be variations. And government of in West Bengal, we are not manufacturing salt. It is imported from Gujarat and the Rajasthan. Very well. Salt is a low value but high volume commodity, and as such, it can be transported by railway wagons only. We are huge consume, my letter. Railway issued circular dated 27 November 2012, granting concession in freight rates of the salt meant for human consumption, subject to production of certificate by the authorized official of the Salt Commissioner, stating the nature and category of salt to be transported through such rake. To give preference in booking of rates and concessions in freight rate for import of the iodized salt from outside West Bengal, A committee was constituted by this honorable court and affirmed by the Honorable Supreme Court, and such committee was required to impanel the salt importers of West Bengal and to recommend their names to the Salt Commissioner, Government of India, and Salt Commissioner to sponsor their names for next. It's very relevant, my lord. Considering the importance and necessity of this particular minerals, the minor minerals salt, the Government of India, my lord, decided, and the High Court as well as Supreme Court passed the order, a committee should be formed. It's a very nice thing, my lord.
So there is a committee.
There's a committee. And they suggested, accordingly, a panel is prepared. I'm in the panel. I'm associations. Accordingly, the names of the accordingly, the names of the impanel importers were recommended by the said committee to the Salt Commissioner, and the Salt Commissioner, Government of India, forwarded the same to the railway by issuing program for allotment of rake.
Yes.
Salt had been loaded in railway rake by the consignor from whom we are purchasing that, my lord. They are actually loaded on the south side state after certification from the authorized official of the Salt Commission of Government of India about nature and correct category of salt and allotment of rake, and such concession in trade rate had been granted by the railway upon such certification. But this is relevant because we are getting a concessions in the rate.
Yes.
So naturally, my lord, based on the certificate. So that is why if we do not import, my lord, iodine salt, we will not get any relaxations. Certainly, office of the
Certificate
salt
from
commission.
official of Salt Commissioner.
Yes, my lord.
Certificate.
Yes.
From the official of the Salt
That's
Commissioner.
because we don't have any. We have got no role. First, my lord, the persons from whom we are purchasing, the consignor, before, my lord, it is loaded in the railway, but a certificate to be obtained from the appropriate authority.
Yes.
Now, certainly, office of the Salt Commissioner was closed, the Government of India, and there was no authorized official of Salt Commissioner, Government of India, at the loading station of other states. And in absence of such certification, the railway issued another circular dated 9th August 2024, directing that the concession will be granted on movement of salt meant for human consumption with the names of the consignor, consignee for the state authority to the railway. That is very relevant. So they say that particular department is gone. The railway authority says very good. Concerned state will take the responsibility. If they are certified, no problem. There's no problem. So naturally, it is being done in this way. However, railway issued another circular that surprise check could be carried out to deduct misdeclaration of goods to avail concession in freight rate by the importers.
That is the crux of the matter.
How to detect? Detect. Sometimes it will happen, my lord. Some, my lord, dishonest persons, my lord. What they do, my lord? They fabricate something, manufacture something, in different way they try to evade, and for wrongful gain, they do some mischief. So railway authority decided certain check. I will tell you, no problem. My lord, remember, I do not know whether knows it or not. There is a system of Boma. You know Boma? What is Boma? I am from village, my lord. I know what is Boma. In the essence of my lord, that so many ghani bags are there, full of rice, many rice. Now there is the chunga,
yes,
which is called Boma. They put inside that. Oh, this is all right. This in this way is checked. In salt case, it is being done in this way. This is very unfortunate, my lord. It is impossible. However, railway issued another license. The state government issued program 20 quarter of the for movement of iodized salt by railway rakes from Gujarat to West Bengal for submission of indents in 3 parts with railway by the importers for loading of iodized salt in railway rakes. Railway started checking of nature and correct category of salt from the loaded wagon by drawing sample 1 or 2 bags. One or two bags behind the back of the consignor, alleged same as misdeclaration in nature of category of loaded salt. Now this is very relevant. I am not connected. I am just getting the delivery in the last point, terminal point. It is loaded by who? Consignor. Now, at that juncture, certificate is being issued, no problem. But railway says random checking, 1 or 2 bags. That creates a problem because salt to some extent is volatile.
Yes.
Now, what checking is done, but today a checking is made before loading. When it is coming here, automatically it will reduce.
Yes.
Nobody can stop it. So many factors are there. In this way, it can be done. That is why earlier certificate was really very good. I don't know why it was stopped. It was stopped. But this type of checking is really most unscientific and irrational. And there may be something wrong. Who is pulling the string? I know. I'll come to that. Kindly see. So this is the case. Consignor and allege the same as misdeclaration in nature and category of loaded salt, so that more revenue may be generated by imposing penalty. Now, this is very interesting. As soon as it is found, it is not in a proper degree, they're imposing the penalty. Upon the consignor, consignee, mainly consignor, because first point is there, they load their goods and then certificate. So naturally, consignor found it's very peculiar game. I am loading everything. Random checking. Just that they say, no, there is some wrong. So you'll have to pay the penalty. So this is another way to realize the money, which they cannot directly, they are doing indirectly, which is very unfortunate. Then, next page. After some meeting held between railway and other government department, railway issued another circular on 14th May 2025 stating that the state will submit program to railways mentioning names of the consignee, and the consignor will place the indent and upload the authorizations program of the state government and also upload quality certificate signed and stamped by the designated authority laboratory of the state government. But this is very, very relevant. I could have understood that well. If anything wrong, I am not responsible, neither consignor. Who has done this for oblique motive? That will also reflected from my statement. I'll come. Some unscrupulous importers started bringing non-iodized, can you see very materials? Some unscrupulous importers started bringing non-iodized salt by railway rates without taking benefit of concession, and railway, to earn more revenue, allowed import of such salt without check of quality. This is very significant because they are importing that, my lord. So they are not taking any exemption, any minor minimum reduction of price. So they are importing. Now, the petition number 1 being the Association of some salt importers by letter dated 13 June 2025 informed the railway that anonymous complaint by some persons who are desirous of controlling the business of salt in West Bengal have been alleging misdeclaration in the nature and category of salt to be imported by the empaneled salt importers to restrain them from importing salt so that they may bring any type of salt by other means and sell the same in market at higher price and request to ignore such anonymous complaint. But very peculiar. If any complaint, with my limited knowledge, my lord, if any complaint is lodged by any persons, is a fundamental principle. Mr. Ashok Banerjee, no, a complaint is lodged, your friend, see the complaint, you are doing this mischief. I could have answered to that properly. I could have said, no, this is not correct. What is their interest to complain to the lodge? Are they connected with the business? Yes, they are also interested. Are they paying the money to the railway? Yes, we are realizing that money. Are they getting that concession? No, they are not getting concession. Oh, there is in market, their price is higher than our, because we are getting subsidy. The amount which you are realizing from our customer, they cannot do that because they are not getting subsidy. So in order to create a pressure and to put us in trouble, they lodged a complaint. We have not been obliged to have any copy of the complaint. And they say on that basis, we started inquiry. In whose presence? It was never been done either in the presence of the consignor or consignee. My lord, I must finally confess, I don't know much idea of the criminal aspect and all these things, but fact remains, if anything is seized, some witness must be there.
Yes.
My lord, unfortunately, at random, one or two, in wagon, my lord, how many bags are there? In 1 and 2 bags, then you must identify that 2 bags. These are the not up to the mark, remove it. You say entire wagons, whatever, entire wagons, rake, not only wagon, rake, entire rake, not proper. Well, how is it? Is it permissible under the law? I'm asking myself. The said letter was forwarded by the railway board to the Eastern Railway, Kolkata, to examine and take necessary action, but no such action was taken. In spite of such circulars and such consignors loaded of salt outside the salt state informed the importers that they are not in a position to load the rake as per program of the state government, since definition of misdeclaration is not clear, and railways may impose heavy penalty alleging misdeclaration despite loading of the quality certificate from the state laboratory. Who?
Exporters.
Yes, exporters also party here. Exporter within the country. So consignor, better I use the term consignor, my lord. Consignor, they must know. And is it that way to check? Not only in wagon, enter rake on the basis of 1 or 2, checking 1 or 2 bags, gunny bags. They say, no, this is not up to the mark. And in transit, there is every possibility of evaporations. The date is there. Let us kindly see here. First page, paragraph 3. According to the Bureau of Indian Standard, the contents of iodine in salt should be 20 to 30. It's stated in the petition itself. For your lordship's convenience and my convenience, I have prepared the note. My junior friend. Why 20 to 30 pp? Kindly marked it, my lord.
Yes.
For obvious reasons. They could have said 20 or 30. Why 20 to 30? There must be some reasons. So if there is a variations, that doesn't mean it is not properly declared. So this is the
limit is 20 to 30 ppm.
Yes.
On dry wet basis.
That's true. That means if it is 25 allowed, if it is 29 allowed, if it is 21 allowed, for obvious reasons.
Yes.
Why you have relaxed? Why you have prepared this note? It cannot be, should not be. So that's why, my lord, kindly come to page 24 of the petition. I have stated
yes. 24 is the
24. What I have stated in my notes to corroborate that this is actually the Schedule 1 standard for fortification of the foods. Then iodine, iodized, iodine,
Iodized.
iodine content.
Yes. Content, iron fortified such and such, can be 20
Excellent.
middle portions, box. 20 to 30 parts, 15 to 30.
Manufacture level, distribution channel including refill, retail level, iron content.
Yeah. Then 15 to 30. So they have given a go by to everything. Just using that particular instrument and 1 and 2 bags, it's not a scientific. It's not, cannot be.
So what is your grievance here?
My grievance is my lord, my consignor. He says they are charging huge amount penalty imposed. So how I will not send any salt in this way. So many states are there, I don't care, I'll sit there. Now kindly see, this is my first grievance. Kindly come to page 19. Have you got it on page 19?
Yeah.
A re-tender in the nature of mandamus commending the respondent to act strictly in terms of the quality certificate issued by the designated laboratories of the concerned state as record, as not my agent. It's the state issuing the certificate. Concerned state, as required by the railways, as per circular dated 14 May 2025 of the Railway Board, Minister of Railway, Government of India, without insisting for further verification of goods or things. Once the certificate is issued, what authority you have got to check it up? If there is even if there is a complaint, you ought to have make an investigation, inquiry, because every time, not that whoever is lodging a complaint with a good intention, maybe some malintention. And when the government issues a certificate, government is doing each a government. And that is also, my lord, the business railway circular. Kindly come to page 33. How they are agree, why they are so overactive? Page 33, my lord. Yes. Have you got it, my lord? Page 33. The last right box, my lord, the last paragraph. For the state of West Bengal, Assam, Sikkim, and Tripura. Because climatic condition is different, my lord, humidity, less humidity. So that's why they are classified some state. Here for the state of West Bengal, Assam, Sikkim, the competent authority of concerned Department of State Government, Food and Public Distribution and Consumption, will submit their program to the railway mentioning the name of the consignee. The consignor will place the intent of upload the authorizations of the state government. Upload the authorization of the state government. The consignor will also upload the quality certificate issued, signed, stamped by the designated authority of the state government.
Yes.
It is called railway own circular. Naturally, my lord, this is actually proper process. I am the state. My subject should not suffer. I am the best person to see that, well, no salt without iodized is taking it from the importing from the other state. It's my duty. I'll be criticized. All the newspapers and the channel, they'll jump up on me. They're knowing fully well why state encouraging some people, which is really dangerous for the consumers. Again, come to paragraph, page 19, my lord. Page 20. My lord, statutory, my lord, always. C, kindly see the C. A retender in the nature of matter prohibition prohibiting the respondent from acting contrary to the circular. The same thing, because they cannot act contrary to that. Private, I can understand. That will not, there is apprehension. It is the state.
Now they are doing some abrupt samples from the.
And not only that, my lord says, no, you will not get a subsidy. And in addition, you will have to pay the penalty. That means they are benefiting both ways. Oblique motive, oblique purpose behind this for some persons, unscrupulous persons. So penalty is consignor will have to pay, consignor, because it's the first obligation. But ultimately you realize unless there is a clause or agreement or arbitrations, they won't be realize the money from me. So my lord is a consignor, and now the consignor will say, I will not supply you because unless I am harassing, it is a huge amount, because they are doing business. And consignor is here. I made them a party. Mainly it is their givens.
Now, are you challenging any order of penalty like that? No.
No. As such, actually, as such, I'm challenging the action. Action. Inaction action can also be challenged under Article 26. If the action is arbitrary, without having any substantial support of the law, and is a malefied, I can come and before the lawsuit.
Yes, yes.
Both action and inaction can be challenged. Kindly come to page 51, just once. I will not detain you lawsuit. Page 51. Have you got it, my lord?
Yes.
Yes. To the Gauri Shankar Agarwal, lastly. Loading of refined salt feed for human consumption. We have received your instruction for loading of non-refined salt mean for human consumption in terms of the program issued by the government of West Bengal, third quarter 2020. It has been instructed from your end that loading of rakes should be done with QC certificate quality control from the state laboratory certifying that the salt so loaded in the wagon is non-refined salt meant for human consumption. In spite of quality certificate, Gujarat government authority not clear so railway check our wagon and not clear about misdeclaration definitions. Salt is low cost commodity and we are smaller plants. We are not bear heavy penalty charges. We are not in a position to load the rake in terms of the program under reference. So I am the worst sufferer. I'm prejudice. My right is prejudice. Can you come to the next page? Sushil Kumar Agarwal. Loading of non-refined salt feed for human consumption in railway rakes. We have received your instruction for loading of non-refined salt meant for human consumption in
Same.
terms of the program. It has been instructed from your end that loading of third paragraph, there is a difference in third paragraph. In spite of quality control certificate, railway only with a motive to earn more revenue is trying to declare the nomenclature of salt contrary to the non-refined salt for human consumption, and as such, we are not in a position to load the rake in terms of the program under program. So it is a railway knowing fully well whatever I am doing with my limited access. First, I am importer. I am importing from another state. My consignor, he is sending the salt, hydro salt to me. Before it is loaded to the rake, certificate is obtained. And that is issued by the government concerned. Why they are doing all these things? I've just noted for two reasons. Number one, to oblige some other persons who are importing without iodized salt. That is not for human consumption, but for other fodder. Now, my lord, that is also risk. If it is mixed up with the iodized salt, nobody will be able to catch. And they impose the penalty. And that penalty will be realized from the consignor. I made him a party. Let him say what is his grievance, whether I'm correct or not.
The railway authority are threatening like anything.
No, let me say something. তুমি বলবে আগে তুমি বলে নাও তাহলে তোমার হয়েছে না হয়নি
না মাইলার যদি কি জিজ্ঞেস করেন আমি বলতে বাধ্য for the timing I think I'm
Okay. So your grievance is the action of the railway authority.
Yes, my lord.
By imposing some conditions upon the importers.
Yes.
Exporters.
Because if they
have written you letter that they are not ready to consign the salt.
Yes, they didn't agree. So my right is my livelihood is at stake. And without import salt, because manufacturing super West Bengal is very nominal amount we are manufacturing in West Bengal. Practically there is no. Now we are importing from Gujarat and Rajasthan. If they do not agree to supply that, those people will suffer.
Yes.
What is the railway doing? If you find, then why did you not inquire earlier? Why did you not say that? Entire rake should be checked up. One bag and two bag, random it can be done. Suppose one gunny bag was iodized just 3 days back. But after assemble, they are sending all this. And another is 4 to 5 days back. So he's taking, without knowing, of course, I'm not blaming for that. He's taking salt from the 5 days back, check back. So naturally, there's every possibility. Whether it is really dangerous for human consumption. If it is really dangerous for human consumption, I can understand.
That is to be checked out. Anyhow.
Yes.
My lord, first thing is, your lordship kindly, I am giving a note there, Indian Railway Commercial Manual, Volume 2, Roman 2. আমি দিচ্ছি তোমাকে দিচ্ছি এটাকে জজ সাহেবকে দিই and the paragraph 1416 and 1417. Your lordship kindly see. দাও একটা কপি দাও কই দাও একটা জজ সাহেবকে দিয়ে দিলাম তোমারটা তো আমার কাছে রইলো
একটু বলবি তো
একটু বলবো তুমি চলে পড়ো
I am taking 5 minutes time.
অনেকখানি বলবো আর বাকি রাখলে কি দাও
ঠিক আছে
Your Lordship, kindly see that I am showing your Lordship.
Page 2.
Page 2, yes.
Yes.
There is a provision under railway manual, and there I can, a certain check can be made. All on a sudden, we can do it. And knowing fully well that.
Which provision you are saying?
Yes, you probably,
One,
Lord,
four.
kindly see. Page 5 of my note. Page 3, kindly see, page 3.
Page 3.
Yes.
Under note 1417.
1417 and 1416, both.
1416 and
Well,
1417.
Your Lordship, kindly see.
1416, what is this?
Misdeclaration of goods by consignors is generally made for the purpose of securing transportation at a cheaper rate than the authorized charge. The articles chargeable at the higher rate being described in the forwarding note as those chargeable at a lower rate. Misdeclaration is also taken for securing booking against restriction orders. The station staff should, before accepting the commodity as described in the forwarding note, check it as far as possible by the actual examinations of the package of a consignment. That is first. Second, my Lord, your Lordship, kindly next page. Kindly see next page. Surprise check to detect misdeclaration. That is the that we can do. That is authorities' discretion. Surprise check should be carried out to detect misdeclaration of goods in same manner as in the case of parcels. That is there. And naturally, my love, we have checked it and we found this is not up to the human consumption. It is not up to that.
Is there any report that you have checked it and find it something?
That is with them. If your Lordship so desire, I can.
Some procedure to check a consignment.
Right. Yes, definitely there is a record. If your Lordship so, yes.
The medicine, like the same way, you cannot check it like that.
No, not that. Not that. Your Lordship kindly, if your Lordship so desire, I can produce the reports also before your Lordship. Because that is on record, their record, I will have to bring them and that will be in a form of affidavit I can place before your Lordship. That is neither here nor there. I can do it. I will do it if your Lordship so direct.
There is a specific circular. By violating that, whether you can check it abruptly.
Not abruptly. I have shown him just now.
You have the authority to check, surprise check the consignment.
Yes.
That doesn't mean you can destroy a bag.
It depends, my Lordship. Not destroying. It's our duty to check it up. So I am asking myself, how can I do that? I cannot destroy. I have no intention to destroy anything. That is railways work. That is not the part of the work of the railways.
No, if you want to check a bag of rice, there must be certain procedure.
Yes.
If you want to check a bag of jute, there must be a certain
every item. Yes.
If you want to check a medicine,
Yes.
there must be a
every item. Yes. But what happened there? That is to be. I will have to take instruction from them. How they have.
How they are checking the.
Yes, that is the procedure, and procedure
must have a procedure. Like
of course, there must be there, and
not
that
the
is
same procedure like.
Yes. No. I will definitely place before you.
Saying that surprise check should be carried out to detect misdeclaration goods in the same manner as in the case of parcel.
Because parcels are also, my lord, parcels are also checked by not removing the strike or but some that is there to there is a machine where from it appears that some other things are inside or not in a parcel. But here it's a bag, gunny bag. That cannot be done in a parcel or something like that. That is to be done in the case of gunny bag.
So by the strength of this provision, you have checked the.
Yes.
So
beyond that, because we have no enmity or with any other parties, but the certificates they have obtained from the supplier, that will not support their case, my lord, because they have said so many things in their your lordship have already has seen that letters. This is a fraud by bagara bagara against the railways because they are businessmen. They are businessmen. That is the reason they will make allegation against me. But I am the authority. I cannot do. I cannot do beyond this scope of this manuals and all this. I cannot do that.
Now, whether there is a specific provision to checking the salt, what is the manner?
Manner. Your lordship is asking me that.
What is the
proceed-
manner?
Yes, procedure.
Is there any provision? Is there any procedure? By rules? By such way we are checking the.
That being a layman, I cannot at the moment I cannot say, but I can ask my junior to contact them and get it from them only. What is the procedure? Definitely, but what they have said in their allegations, no specific instances have been mentioned in the writ petition where Eastern Railway Authority conducted checking of transported salt
That was not
received in the.
mentioned properly. Why they have appeared
Yes,
before this court? No allegation regarding any action of your authority.
Yes, and that allegation, if it is a genuine allegation, yes, your lordship can ask for clarification of that. Yes, your lordship can.
No, the only question is whether they are here in the writ court.
Yes.
Impose or to pass an order of mandamus.
Yes.
So that the railway authority can strictly follow the circular.
No, the interim order they are asking for, your lordship, kindly see prayer F.
Prayer F.
That possibly prayer F. Your lordship, kindly see.
Yes, not contrary to the circular.
Not contrary to the sir. In any manner whatsoever.
Go contrary to the circular 14th May 2025.
That interim order, actually the interim order in this fashion or in this way, no, it cannot be. My lord, this is my submission before your lordship, it cannot be done. Because
no, whether you are denying that there is a circular on 14th of May 2025.
And also, your lord, yes, my lord.
Is there are you denying that there is a circular on 14th May 2025?
No, there is a circular.
Yes. They are following that circular.
No,
whether they are
because
following or
your
not.
lordship kindly come to page 34 of the writ petition.
34.
Yes.
Yes.
Last but
the states other than West Bengal. That is not for West Bengal.
no. Sudden check. Cross checking. I'm talking about the last but third line from last. Page 34. Your lordship kindly. Your lordship kindly see that at the time of sanctioning the rake requirement, railway authority will view the uploaded copy of the forwarding note and cross check the rake requirements because it has to be done. Every point we have to cross check. We have that. And at the top and at page 34 for states other than West Bengal, Assam, Sikkim and Tripura. That is there. I'm not saying that is not there, but we have the liberty to cross check the rake and everything.
Check in case of state of West Bengal, you cannot cross check.
No.
You cannot cross check.
There
is a notification is specific.
No. That no.
The consignment will also upload. There are distinctions for state of West Bengal, Assam, and Sikkim and Tripura.
Circular was issued after the page 32. And page 32, they started surprise check.
Yes.
And then after a meeting was held that they will not do surprise check. And for this, they wanted to implement this circular, that page 33, that if I load the salt with quality certificate, then the surprise check will not be there. That's why your lordship can see page 32. It is advised that surprise checks will be carried out.
Can it be waived?
Misdeclaration.
Manual.
Misdeclaration. As per manual. Now it was the dated 9th November 2024. Considering this, a meeting was held and 14th May 25, this circular was issued.
Issued by the state government.
No, by the Ministry of Railways.
This is the Minister of Railway.
Yes, yes.
They
But thing is,
better you upload the quality certificate from the state authorized officials,
Right.
and then we shall not do this. And that's why there is a difference between the guidelines of state of West Bengal and for other than state of West Bengal.
ওই
14 May is overriding.
আমি দেখলাম
Overriding.
ইন্ডিয়ান রেলওয়ে কমার্শিয়াল ম্যানুয়াল দেখো দিয়েছি ওকে দিয়েছি
কি হয়েছে?
ওটা তো ছিল সেটা
আরে power is one thing and excess of power.
Power is with the railway authority.
No. Power is one thing and misuse of power is another thing.
Misuse,
Of course.
how can you prove misuse?
That I've stated. You need not prove. I am saying. I am saying. A policy must be
an issue there.
No. Policy.
We have an affidavit. Yes, definitely I will do that.
The policy is something else, my lord. That will sometimes it says if the policy of the government like the is arbitrary, there is a violation of natural justice, we cannot challenge. I have got a power. This is not about it. But with the power is exercised in a proper way, or the instance of anybody, that is to be taken care of. And court is the ideal place where court will decide.
That is to be
Now
that
taking
is to
the
be-
power and in the name of the power, you can't do what you like. Why do you not exercise your independence?
That is to be decided
Why
by
did
way
you
of
not
an
exercise your
affidavit, my lord.
independent power? Why you wait up collected
Mr.
an
Banerjee
objection?
is raising voice, but I cannot match with him.
That is a very weak argument, my dear friend. I remember once. I'll tell you also one thing. I don't know whether I've told you also earlier or not. I was arguing. Justice Dr. Devipal, my lord knows that. He used to laugh me like anything. Are তুই আমার flag নিয়ে যাবি একমাত্র লোক. Because even in the Supreme Court, one case was going on. Dr. Devipal or Palkilo was arguing. My matter was fixed at 3:30. I mentioned earlier that was the system. Senior Chandochud and Madana Thakkar. That is that's the very first day of Madana Thakkar. So Dr. Devipal said, my lord, kindly Dr. Pal. Senior Chand is a very Dr. Pal. 12 feet or at least 15 feet you are having for 15 feet. It's all right. Please slow down your voice. Now, one day.
That should not be in this case also.
No. That in those days, my lord, public nuisance, sound pollution, madam. So before Justice Bhavati Banerjee, I was arguing one case. My junior friend, he was completely junior. He said, my lord, he is shouting. That's what he said. Who is shouting? Mr. Banerjee. How long you are practicing here? That is his normal voice. And one day, my lord knows between 17 and 18, there's a wooden partition.
Okay.
So in one contempt matter, Division Bench Presiding Justice Mukul Kumar Mukherjee, Senior Justice Arun Datta. In Howrah Court, Munsef, my lord, at that time there's a Munsef, he just expressed his helplessness. That this is the position. They are threatening me. They are violating everything. That was sent to the High Court for questions. I just fought like anything on behalf of the Munsef, Ladin Munsef. She said, what is this? Justice Mukherjee, no. So Justice Arun Datta, no. Here we should interfere. So naturally, my voice was raised. On the very next day, I entered into the room number 17, court room number 17. Justice Umesh Banerjee said, oh, Mr. Banerjee, just a minute. Well, Mr. Banerjee, yes, my lord. Can a judge hear two cases at a time? No, my lord, it is not possible. Mr. Banerjee, I'm asking you, can a judge hear two cases at a time? I'm answering, my lord, it is not possible. That was done, that has happened. Well, like, what are you taking? It can't be. Yesterday, when I was hearing one matter, suddenly I found one lawyer is arguing in the next room. I just told them, my dear friends, wait, let me hear Mr. Ashok Kumar Banerjee. Then I hear that. So nowadays I don't shout, I just say, কণ্ঠ আমার রুদ্ধ আজকে বুঝলে সেদিন
Because of age, ছাড়ো না। আমি যা করতে
বুড়ো
ছেড়ে দাও।
বলবি না,
বুড়ো বলবো না।
So my lord, this is the situation. Power is one thing. Misuse or malexercise of power, that is always required interference of the court. And my lord, how the program will be finished? Kindly see.
One program is already over.
One program is already over. Page 40, my lord. Kindly come. For the benefit of the West Bengal people. Well, page 38, my lord. That there is 38 first. The program indent, have you got page 38? Page 38, my lord.
Program for movement of the.
Yes, yes, very, very material. At page 38, my lord. Second part. Second block. Indent may be accepted from 15 June 2020 to 27 2020. That is gone. I've lost it. Calcutta page 40, my lord.
Program.
Part. Haven't you got to part 3?
Third part. Yes.
Third part. Indent may be accepted from 30th July 2020 to 12th September 2025. So again it will lapse. And who will ultimately suffer? The people of West Bengal.
No, no, not.
You can pressurize me to earn more money, but you cannot get in problems with the West Bengal. But salt is such a thing, maybe not high cost, but even the poor people they want. My friend is very rich man. He has got a very big house in Goriata, and he invited me several times. So he will not suffer because his doctor advised me, advised him not. পথে এসো বড় লোকরা নুন খায় না, আমাদের গরিব লোকরা নুন খায়, পাতে নুন ছাড়া খেতে পারি না।
বিষাক্ত নুন নয়।
না, আমরা গায়ে
পয়জনাস।
না, পয়জনাস তো নয়। So kindly protect us for the timing, my lord. They should not disturb at least. A consignor is here. Kindly assure them they should proper.
Okay.
Give me some time, my lord, so that I can, on the in a form of report, I can give the whole total details from the department after going through their record.
I don't mind, but in the meantime, you cannot stop it.
In the meantime, there cannot be much.
But how can it be? The people will suffer, already they are suffering. And how will
you have skipped two matters.
Then
2 dates. So
that's why that
people are not suffering.
because I have skipped for your fault 2 days. So I must miss the third place.
No, wait for 7 days.
What 7 days? 12 September.
12th of August.
Already an entire rake
within 1 week, heaven will not fall.
Heaven will never fall, my dear friend. I can assure you. But I'll go to the hell.
It doesn't matter.
Heaven will never fall.
Doesn't matter.
You are trying to put me in hell.
No.
It is really between the concern and concern. Keep an eye. How we are practicing? Keep an eye. No, keep an eye. Every wagon to be tested.
Yes.
Every wagon. Keep an eye. I don't mind. Keep an eye.
No,
you keep an watch.
That is my prerogative. I can. But the thing is, your lordship, 7 days, I will file my report.
I am praying on the quality certificate. If there is no quality,
in the meantime,
I'll be penalized.
Date is of 12th of September. Time is there.
It will take some time.
It is not required.
So many.
In the meantime, your lordship can dispose of the matter.
How is it no matter?
Then আমি যদি দিয়ে দিই রিপোর্টে যদি
তুমি অনেকেই দিতে পারো, সেটা যাই হোক, তুমি দেবে কিনা তার কোনো ঠিক
না within 7 days, yes. Why not? জজ সাহেবের ডিরেকশন থাকলে কেন দেবো না?
If there is a problem, I can understand. There is no problem. Because so far I am concerned, nothing. But consignor, he will not supply the salt to me.
Very good.
He is afraid of.
Yes, hard.
Not a single complaint from the consumer. So we are concerned.
হবে না, ছেড়ে দাও, বসো। দুটো হবে, একটা।
Not a single complaint from the consumer. It is a food stuff, not a matter of joke. Nobody will spare me.
তুমি তো খাও না, তোমার একটা আছে।
না, আমি নুন ছাড়া খেতে পারি না ভাই, আমার নুন চাই, গায়ের লোক। থালা এক গাদা নুন নেবো, একটু করে টাচ করবো, খাবো। হ্যাঁ, না আমি মরবো ভাই, আলু নি খেতে পারি না।
নুন তো খাও না, অনেক নুন দরকার আছে।
অনেক কিছু।
My lord, the railway authority are threatening us like anything. They
Why
just
threatening?
put us on threat of imposition of penalty.
Then
that I don't know.
Problematic part of this issue is there is nothing documented.
That's very vital.
Nothing documented.
That I will place before your lordship.
Document না থাকলে প্লেস করে কি? আমাদের দেখালে নাকি কিছু না।
They are just
Let me satisfy your lordship.
Nobody is stopping them from doing random checks.
Yes.
But in the name of random check,
They can kindly clarify that. Kindly clarify that.
In a wrongful manner.
That
And after we are supplying the quality certificate.
your lordship has to be
According to
satisfied with that. Their statement from the
Why-
bar.
no, no.
Statement
Why-
from the
why you
bar.
are- no, no, I'm not, I'm not.
And even then, they are doing all these things.
Threatening and bagara. Everything.
No question agar bagar. I'm not saying agar bagar. Don't say agar bagar.
কি আবার কি বলছো?
Fact.
No, no. How can court know that this is a fact?
We have explained.
Your
You-
audio
you-
audio
Arre bhai,
statement.
when you have
That
received
cannot
the,
be.
today you have come with a manual and you have not come with a record. This is funny.
No, record unless court directs I cannot.
Is it?
Yes.
For the first time came to learn.
First time.
So kindly protect us for the
And that too
without
internal
certificate,
documents, unless your lordship directs, I cannot bring it.
you can keep it to what you talking about.
No, no,
That-
I will place it before.
না তাই তো করবি আমায় দিবি না আমারও 52 বছর হলো
Is for the respondent, private respondent, private respondent. You are respondent number
7.
7.
The letter which I have annexed, which has been annexed, is at page 52.
Okay. 52, yes.
Part of annexure P9.
First thing, railway, no way will be prejudice. Number one. Number two, I'll both concernee will suffer. And last one, very important, even the consumer will suffer. Let there be one complaint, I'll stop my business. I can as well as my God. But this is not the way to realize the money in this way.
Okay, please take down.
Certificate is there.
চেয়ার তো দিচ্ছে তুমি বসো না 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 বসো বসো বসো
Can I sit, my lord?
না কেন কেন সিট তুমি ওটা না তোমার বয়সী তোমার থেকে বড় বাচ্চা 2-3 বছর ছোট আমি বলি না
Number 1 is an association of salt importers of state of West Bengal who import iodized salt meant for human consumption from other states.
But I'm begging 2 minutes time to take one.
From other states. For importing such salt, termed as non-refined salt, mean for human consumption, there is a freight rate of the Ministry of Railway for transporting the same through rake. Full stop. Initially, Railway issued circular dated 27th of November 2012, granting concession in freight rates of salt meant for human consumption, subject to production of certificate by the authorized official of Salt Commissioner, stating the nature and category of salt to be transported through such rake. Full stop. To give preference in booking of rakes and concession in freight rates for import of iodized salt from outside state of West Bengal, a committee was constituted by this court and affirmed by the Honorable Supreme Court. And such committee was required to empanel the salt importers of West Bengal to recommend their names to Salt Commissioner, Government of India, Government of India, and the Salt Commissioner to sponsor their names for allotment of rakes to the railways. Full stop. Accordingly, next part, the name of empanel importers were recommended by the said committee to the salt commissioner, and the salt commissioner, Government of India, forwarded the same to the railway by issuing program for allotment of rakes. However, the office of salt commissioner was closed by the Government of India, and there are no authorized officials to issue certificate. The full stop. The railway issued a circular dated 9th of August 2024, directing that the concession will be granted on movement of salt meant for human consumption, with the names of consignors / consignee by the state authority to the railways. Full stop. The railway also issued another circular on 9th of November 2024 that surprise check would be carried out to deduct misdeclaration of goods to avoid concession in freight rates by the importers. Railway started checking nature and category of salts from the loaded wagons by drawing samples from 1 to 2 bags behind the back of the consignors and alleged that the same as misdeclaration in nature and category of loaded salt, and impose penalty. Full stop. Thereafter, some meetings were held between the railways and other government departments. By such, railway issued another circular dated 14th of May 2025, stating that the state will submit program to railway mentioning the names of the consignor / consignee, and the consignor will place the indent and upload the authorization within bracket program of the state government, and also upload quality control quality certificate signed and stamped by the designated / authorized laboratory of the state government. Full stop. It is the allegation of the petitioner that some unscrupulous importers started bringing non-iodized salt by railway rakes without taking benefit of concession, and the railway to earn revenue allowed import of such salt without check of quality. Full stop. It is the case of the petitioner that in pursuance to anonymous complaint, the private anonymous complaint by some person the railway authority started checking the consignment, violating the circular dated 14th May 2025 and imposing and tried to impose huge penalty upon the importers within bracket upon the try to impose heavy penalty upon the empaneled importers. One of such importers has written letter to the petitioner that in spite of quality control, railway, only with a motive to earn more revenue, is trying to declare the nomenclature of salt contrary to the non-refined salt for human consumption. By such, they are not in a position to load the rake in terms of the program. Full stop. It is the contention of the petitioner that the act and action of the railway authority devotes to the circular dated 14th of May 2025. So the railway authority may be restrained to act, no, maybe directed to act in accordance with notification dated 14th May 2025. Full stop. Learned counsel appearing on behalf of the state, on behalf of the railway, raised strong objection and submits that the railway is acting within the authority during full stop, during transportation of any goods. They have the authority for supply check to detect misdeclaration of the goods. By such way, the railway authority actually wanted to check the quality of the salt supplied by the exporter to the petitioners. Full stop. It is the further contention of the railway authority that that the purpose and manner of checking the quality of the salt can only be apprised this court, can only be apprised before this court by using affidavits to that effect. Having heard the learned counsel for the parties, learned counsel appearing on behalf of the private respondent, number 7, submits that in the name of surprise check to detect misdeclaration, the railway authorities are threatening to the private respondent. Thus, they are in fear to transport the non-refined salt for human consumption to the petitioners. Having heard the learned counsel for the parties, considering the entire matter before this court, it appears that the petitioner has approached this court seeking mandamus upon the railway authority so that the railway authority may act in accordance with the circular dated 14th May 2025. Full stop. The circular dated 14th May 2025 is placed in the record as Annexure P5. The necessary portion for the said circular is required to be set out for better appreciation of the facts. देखो ठीक है page 33. From the above circular, it appears that for the state of West Bengal, Assam, Sikkim, and Tripura, the consigner has a duty to place the indent and upload the authorization of the state government. The consigner is also directed to upload the quality certificate issued within bracket signed and stamped bracket closed by the designated stroke authorized laboratory of state government. But it appears that for the state of other than West Bengal, Assam, Sikkim, and Tripura, there is a provision for cross-check of the rec in respect of the already sanctioned program. It is the contention of the railway authority that for the purpose of surprise check and to detect the misdeclaration, they used to take samples of salt from the consignment. Full stop. The learned counsel appearing on behalf of the railway board could not place any notification or authorization or circular of the railway board that the consignment for the state of West Bengal, Assam, Sikkim, and Tripura, a cross check can be done. So after considering the entire matter, it appears to me that the railway authority cannot cross check the consignment of salt for human consumption. It's a human consumption for the program of state of West Bengal, Assam, and Sikkim, and Tripura by taking surprise check and cross check like other states. Good stuff. The respondent authority is directed to submit a affidavit in opposition stating thereby against the writ petition, stating thereby against the writ petition, comma, stating thereby manner of cross check and surprise visit and cross check and surprise check conducted by the authority in respect of the salt. Full stop. Let the affidavit be placed on record within 3 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Considering the nature and circumstances of this matter, also considering the fact that the petitioner has not participated in the first and second program for this year, and the third part of the program has already been started on 30th of July 2025 and going to end on 12th of September 2025. I think it necessary to pass an interim order to protect the petition. Under the above observation, there shall be an interim order in terms of prayer F of the writ petition, prayer F of the writ petition till a period of 4 weeks from date.
4 weeks, my lord.
4 weeks from date.
For interim, your lordship have passed direction for 3 weeks and 2 weeks.
5 weeks.
Yeah.
So 4 weeks should be there.
My lord, the
4
other
weeks going to end when?
no, 4 weeks will be going to end on 12th.
September.
Within the program,
My lord,
I am protecting you to
but
the program.
further program is also on the process, my lord.
That is not subject matter in this matter.
Yes, you come.
No, let it be 5 weeks because at least this is today is 12th. It will end on 10th. 4 weeks.
5 weeks means after puja it would be.
Yes, yes.
You come before puja. That would be better. Let the matter go out of this party delivery.
My lord, 5 weeks not work week.
Today we are on
12th August.
12th August.
Yes.
12 September. Our holiday is in the month of September.
No, September, full September end.
Full September is there.
September থেকে তো আরম্ভ।
You have to, otherwise you have to mention it. Otherwise you cannot.
Till 19.
4 weeks.
কি
4 weeks from there. Next.
ও ঠিক আছে। আবার কি থেকে বেশি কি হবে?
ওটা আছে কিছু। দেখুন।
Yeah, please, Your Lordship. I'm for the petitioners in all these matters.
I am opposing.
Yes. Lord, to recapitulate, Your Lordship, I'll place it in a very brief manner. Lord, petitioner before Lordship was the decree holder.
2467.
In terms of the order of the Supreme Court.
Yes, Lordship. A decree holder wherein in respect of 7 suit for eviction, wherein Honorable Supreme Court for the first time had decreed the suit on the ground of building and rebuilding. That is section 18A, 13(1)(f), and directed the parties.
Old Act.
Yes, of 56 Act, and directed the parties to follow the provisions of section 18A. My lord, there was a further direction upon the learned trial court to pass a formal decree for 2 reasons, Your Lordship. That by the time the sanction plan expired, so a renewal of the plan, and further to allot the tenant their respective spaces which they were occupying. 50% of its actual space they were occupying. That ought to be varied or reviewed. That is before the corporation. So, and there was a direction within certain specified time, the trial court was directed to pass a formal decree. And pursuant thereto, Your Lordship, the trial court, being the city court at that point of time, passed a decree. But in the meantime, Your Lordship, the plan was reviewed and we had to file an execution case. And we obtained possession because they did not give the possession. We had to file execution case, and after means police help, enhanced police help, we could obtain the possession almost after 10 years, irrespective of that. Thereafter, Your Lordship, after obtaining the possession, we constructed the building. Part of it we could not complete it due to various reasons. And in pursuant to order of this Honorable Court, the execution case kept pending even after obtaining back the possession. The tenant judgment data filed applications for obtaining back possession in my said applications. It's pending execution case. Challenging, and there are orders were passed out there. Then we challenged the said application before this Honorable Court. And in this honorable court passed an order in CO 101 that directed them to file application afresh. That is before the executing court being the small causes court. My lord, we challenge, they filed that application, execution case. We made application that interiorly had objected to that you are not entitled to put the executions out here. Pursuant, because as per the judgment of the Supreme Court, as well as per the provisions of section 18(1), you are entitled to proceed, file your execution case before the rent control. So that was it, your lordship. The application was turned down and the executing court is proceeding. Last time, your lordship, last occasion, they filed an application under Order 40 Rule 1 that was heard out. Subsequently, I filed a miss case for police help. And we have been forced to cross-examine them. We did cross-examine. The witness of the petitioners, we've been cross-examined in all the 3 cases. So we all along raised our objections that before the executing court, that you are not in a position to go behind the back of the decree, because the Supreme Court had specifically stated certain provisions to follow and you are not following that. But my lord, the executing court is irrespective of the said judgment and decree passed by the Honorable Supreme Court and is proceeding with this. So we stated this much, your lordship, and your lordship has opined that since a coordinate bench of this honorable court has passed an order, your lordship what to follow. So in that occasions, I'll be referring and relying upon the provisions of Article 141 and 142, and several judgments are there. I will cite only 2 or 3. And those things, your lordship. 141, your lordship, and 142 specifically speaks out. My lord, it's all, my lord, that Supreme Court to be obeyed by all the courts.
Supreme Court has been considered, my lord, and order has been passed by the coordinate bench. The same point was taken, this point was considered, and this argument which is advancement, that was not turned down by saying that no, Supreme Court has specifically directed that the court has to pass the decree. I'll show that. But the point has been already decided.
Yes.
May I just show me that he's saying that it has to go to the rent controller. The Supreme Court has categorically said that the civil court has to pass consequential order so that the tenant is.
It was done. It was done.
Completely misleading.
Yes,
and
it
wasting
was
the time
done.
of the court.
It was done.
I can do it in 5 minutes. I'll kindly come to the Supreme Court order.
Yes.
What the Supreme Court has said. Kindly come to page 37 once.
So can we continue? Can we continue at 2 p.m.?
At 2 p.m., your lordship, I have a matter in the trial court. I have to go.
Tomorrow. I'll try to be as brief as
Similar
possible.
matters, all the similar matters.
All similar. Same
all the
point,
similar
my lord. His point is that under section 18 capital A, the application has to be made before the rent control. And the Supreme Court has said that 18A has to be followed. So his logical conclusion is that so you should go before the rent controller, not before the civil court. This is the moot point he's taking.
Yes.
I say that this point has been taken care of already. I'll just show. I'll not take.
Who
much
has
time.
taken care of? My lord, the
I'll show.
Supreme Court judgment is still
Supreme Court has
standing as
taken
it
care
is.
of. I'll show.
Tomorrow,
Yes.
tomorrow আছে সাড়ে সার্ভারটা ধরা যায় না সাড়ে 10টা সার্ভারটা কিছু আছে tomorrow 12:30 fixed one.
Fine.
Tomorrow 12:30.
Yes, lordship.
Tomorrow 12:30.
My matter has been passed over 35. I'll let the matter be taken up on 25th. In the coming week, I'll not be here, madam.
Item number
35. Red Town matter.
okay.
They are
The
not
first
happy.
matter, first mention matter
25.
35.
Item 35, let it be taken up on 25th, my lord. Coming week, I will not be here, my lord. 25th, 26th, any day as your lordship convenient.
Same position 25.
I will inform them.
Number 35. Let the matter be appear in the list. Item number 35. Let the matter be appear in the list on 25th of August 2025 in the same position. You inform
I will inform Sonal.
Planet AG.
Yes, I will.
My lord, kindly hear my case today at 2 p.m.
2 p.m. I have what is your item number?
67. The morning I mentioned
57.
67.
67.
Date has already been passed.
67. Okay. To be mentioned matter 1. How many 2 p.m. matters are there? Many matters.
There are several matters at 2 p.m.
All the matters will not do. Maybe several matters. I will take up 2 p.m. matters. Thereafter, I will take up the list.
Then at least at 4 p.m. today, if it is possible.
I will take up this matter. All the matters, no issue.
Malad,
There are no such big matters.
Malad, instead of 26, let it be on 26.
Okay, 26 করে দিন তো
26th. 26th August হবে। Item number 30.
Milord, as per your lordship's instruction, I have served copy upon the learned government advocate appearing the Mr. Chondi Charan. No, no, my lord, if I remember right, on last occasion, at the time of hearing, it was my submission, state authority violated section 4 and consequently section 6. And it was the ulterior motive of the state to procure the entire land and to be given to the HITCO.
Yes.
And section 17(1), section 17(4) applied with a view to avoid 5A of the Act, because we have not given any opportunity of hearing at the time.
Invoke emergency provision.
Yes, invoking emergency provision. And
Without any basis.
It was my submission at that point of time. There was no time in the world there was an emergency provision. If we do follow the Act for construction of city, development of city, it does not come within the purview of emergency provision, as I say. So, on last occasion, even it was my submission that I was relying upon some judgments of the Honorable Apex Court to justify my claim. And if we do follow these judgments, it will come to light that the state authority, what action taken by what action taken by the state authority was absolutely illegal and unwarranted even to that extent. My lord, first, I was relying upon judgment, Union of India, other Mukesh Sons. My lord, this is the judgment. नियम जुड़े बोल बेटा बीच में सुना पे मिनट
To court against that court against that.
একটা দেখেন একটা কপি নেই একটা দিয়েছি আর একটা
Yes.
Union of India and other questions. Supreme Court cases 2004 8S6. To that were AC page 14. Page 14.
Paragraph.
Malot, I tell you. No, sir. Extra gifts you have to look for some. Page 24, 25, 31, 32, 33. The matter, just in a nutshell, I'm telling your lordship the headlines. Right of owner, person interested under section 5A. Nature of section 5A inquiry held can be dispensed with only after the appropriate government forms an opinion that along with the existence of urgency under section 71 or unforeseen emergency under section 72, there is also need to dispense with section 5A inquiry. Mere existence of such urgency or unforeseen emergency not by itself sufficient. Rule against redundancy applied for interpretation. Further held the limited right of a owner person interested under section 5A To object to the acquisition of privilege is not an empty formality, but it is a substantive right which can be taken away only for good and valid reason and within the limitation prescribed under section 17(4). Hence, such a decision must be based on material and record. In the present case, notification under section 4(1) showing the need of land for conducting the concluding ceremony of a festival, declaring a 71 to be applicable and dispensing with section 5A inquiry. In connection with on the last occasion, I made submission before your council that section 4, the notification, at least 2 newspaper, local newspaper and people in a public place, so that easy access of people there. That was not done. Instead, in the local daily newspaper, as they are saying so, and the ABTV in opposition, but fact remains, it was Ganashakti, a party mukhopatra. And second, second, Asian Age. Asian Age. And it was my submission at the
No, I'm
court.
sorry to interrupt. Since he has mentioned the Ganashakti, now a petition was, people just Sunji, petition moved that Mr. Bhupika Bhattacharya. My lord, we are not getting advertisement. Only the others are getting advertisement. So I showed Justice Banerjee the earlier reason. Can you have a look how many advertisements given to Ganashakti? And there is no obligations on our part to give advertisement. Justice Sunji Banerjee says, no, he'll have to do that. And my friend, he was there.
Milord, he does not hold good in case of me. I am Subir Bhattacharya. Bigger question. All right.
তুমিও ভরছো বলে তোর ছিলে
What my lord referred.
okay.
That's and that. That's why an Asian Age, not a what Asian Age, at that point of time, if I say so, even to the extent of 2% people had a knowledge to go through Asian Age. And that's why, according to our section 4, notification was absolutely bad. As I referred, 204 of the application itself, the notification, where section 17(1)(74) applied, and according to it's the governor, on behalf of the governor, according to that we had not given any opportunity under section 5A. We don't hear paragraph 24, 25, 31, 32, 33, I do rely upon it.
Yes.
Next one is ESCO Clubs Private Limited versus State of Haryana. 2009 to Supreme Court, page 377. I'm simply reading paragraph 41 and 42. Whereas subsection 1 of section 17 deals with cases of urgency.
Para 41.
Para 41.
Yes.
Page 389.
Yes, proceed.
Whereas subsection 1 of section 17 deals with the cases of urgency. Subsection 2 of said section covers cases of sudden change in the channel of any navigable river or other unforeseen emergency. But even in such cases, that is, case of urgency or unforeseen emergency, inquiry contemplated by section 5A cannot ipso facto be dispensed with, which is clear from subsection 4 of section 17 of the Act. That's why I do rely upon, on this score, earlier occasion I make submission, and that's why so many paragraphs are there, it will come to light that this action taken by the state government at that point of time that has no basis and absolutely illegal. section 42, paragraph 42, page 389, next paragraph.
Yes.
Subsection 4 of section 17 is an enabling provision, and it declares that if in the opinion of the appropriate government, the provision of subsection 1 or 2 are applicable, it may direct that the provision of section 5A would not apply. It is therefore clear that the legislature has contemplated that there may be urgencies or unforeseen emergencies. And in such cases, private properties may be acquired, but it was also of the view that normally even in such cases, that is cases of urgencies or unforeseen emergencies, the owner of property should not be deprived of his right to property and possession thereof without following proper procedure of law as contemplated by section 5A of the Act, unless the urgency or emergency in such nature that the government is convinced that holding of inquiry and hearing of objection may be detrimental to public interest. Ultimately, at the end of the week, it will be evident that which land was acquisition by the state government, কাটে sorry figure there is Supreme Court. Last paragraph, if your lordship goes through, I mean only if I go through 30, 20 pages, it would be taking much of valuable time of learned court, honorable court. Huh? Okay. Now, Milord, AII 2011 Supreme Court 3389. 3389.
দাঁতগুলো কথা না সব ফসকে বেরিয়ে যাচ্ছে দাঁতগুলো কথা
আসলে
কিছু কথা তো দাঁত ফসকে বেরিয়ে যাচ্ছে
3389.
Yes. Paragraph?
Paragraph 12 and 13. Page 3392. We have considered the respective submission, argument, and carefully scrutinized the record. In our view, the reasons assigned by the division bench of the High Court for setting aside the order of the learned single judge are legally unsustainable. Section 4 of the Act, which provides for publication of preliminary notification, reads as under. 4. Publication of preliminary notification and powers of officers thereupon. 1. Whenever it appears to the appropriate government that land in any locality is needed or is likely to be needed for any public purpose or for a company, a notification to this effect shall be published in the official gazette and in 2 daily newspapers circulating in that locality, of which at least one shall be in the regional language, and the collector shall cause public notice of the substance of such notification to be given at convenient places in the said locality, the last of the dates of such publication and the giving of such public notice being hereinafter referred to as the date of publication of the notification. Next, para 13. A reading of the above reproduced provision makes it clear that the notification issued by an appropriate government in proposing the acquisition of land must be published in the official gazette and 2 daily newspapers having wide circulation in the locality, of which at least one shall be in the regional language. Not only this, the collector is under obligation to ensure the public notice of the substance of such notification is given at convenient place in the locality. This court has repeatedly held that the requirement of publication of notification in the official gazette and 2 local newspapers is mandated.
My lord, I've just finished another matter is called. I'll come back, my lord. It is my pleasure to come, but another matter is called, my lord.
Yes. Division bench of the High Court upheld the acquisition of land by assuming that notification dated 14/5/1985 issued under section 4(1) must have been published in the official gazette because the declaration issued under section 6 was published in the official gazette. In our view, this approach of the High Court was clearly erroneous. The question whether the notification issued under section 4(1) was published in the official gazette is a question of fact, and such question cannot be decided on assumption and conjectures or interference. Whether the acquisition of land is challenged on the ground that the notification has not been published as per the mandate of the statute, the authority defending the acquisition is under an obligation to produce evidence in the form of documents to prove that the requirement of publication has been complied. In the absence of such evidence, the court cannot decide challenge to the acquisition proceeding by assuming that the particular notification had been published as per the requirement of law. In the present case, no material was produced before the High Court, and none has been produced before this court to show that notification dated 14/5/1985 issued under section 4(1) of the Act had been published in the official gazette. Therefore, the High Court was not justified in declining relief to the appellant by assuming that the said notification must have been published in the official gazette, because other notifications, including the one issued under section 6, were published in the official gazette. Ultimately, in the result, 15 paragraph, in the result, the appeal is allowed, the impugned judgment is set aside, and the order passed by the learned single judge is restored. The respondents are directed to pay the amount of compensation to the appellants in terms of the order of the learned single judge within a period of 3 months, etc. But our contention was foremost that section 4 and considerably section 6 were erroneous. Yes, and state did not follow the principles as per laws. Madam, this is judgment. ওটা কত? এটাই কোর্টকে একটা দিতে হবে। AIR 2011 Supreme Court 2582. Page 2582. Paragraph 8 and 9. Just 1 or 2 paragraphs I'm going through. The issue before us is no more case integral, as it has already been decided by this court in Radhesham's case, 2011-5 SEC 553. Yes. Supra, in which one of us was the party, wherein this court has considered the development of the jurisprudence and law with respect to invoking of the urgency provisions under section 17 vis-a-vis right of the landowner to file objections and opportunity of hearing and inquiry under section 5A of the Act. By referring to plethora of earlier decisions of this court had called out various principles governing the acquisition of the land for public purpose by invoking urgency. Thus, from the analysis of the relevant statutory provisions and interpretation thereof by this court in different cases, the following principles can be called out. Eminent domain is a right inherent in every sovereign to take and appropriate property belonging to citizens for public use. To put it differently, the sovereign is entitled to reassert his domain over any portion of the soil of the state, including private property, without his owner's consent, provided that such assertion is on account of public exigency and for public good. Darakadas, Shiv Nivasan, Nivas versus Solapur Shipping, etc. etc. Next paragraph.
Yes.
The legislation which provide for compulsory acquisition of private property by the state or in the category of expropriatory legislation, and such legislation must be construed strictly. GLA put up Enclave Complex Education Charitable Trust versus State of Haryana, 2000 TSC 1648. Though in exercise of the power of eminent domain, the government can acquire the private property for public purpose, it must be remembered that compulsory taking of one's property is a serious matter. If the property belongs to economically disadvantaged segment of the society or people suffering from other handicaps, then the court is not only entitled but is duty bound to scrutinize the decision of the state with greater vigilance, care, and circumspection, keeping in view the fact that the landowner is likely to become landless and deprived of the only source of his livelihood to shelter. In the instant case, there are two cases. Some facts are different, but the real state is this. The principle will be same. And the judgment I'm submitting before your conscience, and I rely also in that case also.
Yes.
But some factual aspect are different. Here I to see no notification to get action, no question was arise of hearing. Next question, state also admitted that out of 277 plots of land, only 27 were acquired. Those are barren now. Even in this case also, the first one, barren land, and even the local gang already encroached a portion with the help of administration. My lord, next one, Radhesham versus State of PP and others, Supreme Court of India, 2011. Supreme Court, page 429. Page 429.
It is with me. It is in the record. We have already earlier placed it. Radhesham.
I've already mentioned in earlier judgment, the Radhesham is noted judgment. Below, try to rely upon the paragraphs 6, 12, 19, 20, 22, 24, 29, 41, 44, 55, 60. Again, I 6, 12, 19, 20, 22, 24, 29, 41, 44, 55, 62. আপনার ঝাল লড়তে গেলে তো একটু কাজ বই দেখতেই হবে। Madam Doctor, shall I hand over it?
I have a copy.
Next one is Darshanlal Nagpal by others, the government of NC Delhi and others. 2012 Supreme Court of India. AIR 2012 Supreme Court. page 412, এই সব এই যে পেপার। এইটার সাথে মিলিয়ে যাবে। প্যারাগ্রাফ বলে দিচ্ছি, বইয়ে মিলিয়ে নেবে।
It's India Kanun version.
Yes, my lord. Darshanlal Nagpal and other partners, government of NCT of Delhi and others. I rely upon paragraph 11, 12, 13, 18, 21, 28. Paragraph 11, particularly, it deals with section 71, 17.4.
Yes.
17.1 and 17.4 of the Act. And some of the state amendments for different public, for paragraph 11 I'm reading. For construction of houses for poor and the members of reserved categories, establishment of medical college, construction of sewerage treatment plants under the court's order, and for construction of expressway has been approved. As against the acquisition of land by invoking the urgency provision for the public purposes like planned residential, commercial, industrial, and institutional development has been disapproved by Narayan Govinda Gavati Master State of Maharashtra. It was our contention. In the name of development of Rajarhat New Town, vast area was acquired. Most of the land is now barren. Nothing has been done, but we are in dire straits at the point of time. No opportunity of hearing, nothing has been done by the authority concerned. More or less, this paragraph, if I go through, the similar circumstance, people are there, the great petition here.
Yes.
Next one.
It
Lakshman Lal, the state of Rajasthan and others. It's a judgment of the Supreme Court through website. I've got it. আমি দিতে হবে তো অ্যাপ কপি করতে পারি।
Very difficult for us, Lordship, to follow the.
Yes, this is India Kanun version.
Fact remains the order passed by Supreme Court on 1st March 2013.
Very difficult for us.
That it will be easy when I will supply copy to you. Milord, I was relying paragraph 18, 20, 21, 23, 28, 33. Paragraph এই যে ফার্স্ট মার্চ 2013 they couldn't figure. দিয়ে দেবো এখন তো ঝামেলা করবে paragraph 18 below. In Munshi Singh and other from the Union of India, this court explained the importance of Section 5A in the following terms. Section 5A embodies a very just and wholesome principles that a person whose property is being or is intended to be acquired should have a proper and reasonable opportunity of persuading the authorities concerned. The acquisition of the property belonging to that person should not be made. We may refer to the observation of this court in Nandeshwar Prasad versus State of UP, AIR 1964 Supreme Court, 1217. The right to file objections under Section 5A is a substantial right when a person's property is being threatened with acquisition, and that right cannot be taken away as if by a side wind. Subsection 2 of Section 5A makes it obligatory on the collector to give an objector an opportunity of being heard. After hearing all objections and making further inquiry, he is to make a report to the appropriate government containing his recommendation on the objection. The decision of the appropriate government on the objection is then final. The declaration under Section 6 has to be made after the appropriate government is satisfied on a consideration of the report, if any, made by the collector under Section 5A(2). The legislator has therefore made complete provisions for the person interested to file objections against the proposed acquisition and for the disposal of their objection. It is only in case of urgency that special power have been conferred on the appropriate government to dispense with the provisions of Section 5A. Yes. Section paragraph 28. All this that there is much of relevancy with some paragraphs also. In spite of that, I would again bring to your kind notice paragraph 28. In this case, as noted above, the preliminary notification under Section 4 was issued on 5/1/1980. After lapse of about 7 years on 19/3/1987. One fine morning, the state government issued declaration under Section 6 without complying with the mandate of Section 5A. And in the declaration, it was stated that it has invoked its powers conferred under Section 17(1), read with Section 17(4) of the 1953 Act, and dispensed with the provision of Section 5A. Had the state government intended to hold and complete the inquiry under Section 5A, it could have been done in few months. However, no steps for commencement of the inquiry under Section 5A were even taken by the state government. We find that a very valuable right conferred on the landowner person interested under Section 5A has been taken away without any justification. It is so because the bus stand construction would have taken some time. The exercise of the power by the state government under Section 17(1) read with 17(4) of the 1953 Act, and dispensation of inquiry under Section 5 cannot be legally sustained and has to be decided as such. Well, that in our case, 20 years have passed, but there are barren lands, no notification whatsoever has been issued. Well, next one, 2016, 13 SCC. Page 210.
Paragraph?
Paragraph 7, 14, 16, 17. Greater Noida Industrial Development Authority versus Savitri Mohan. What na? 50 বছর। The division, paragraph 7, page 13. The division bench of the High Court, following the decisions of this court, referred to above, held that power of dispensing inquiry under Section 5A would be exercised in exceptional situations and not without real urgency. In the present case, invocation of urgency was not justified. The judgment of the full bench in Gujarat was distinguished on the ground that therein the writ petition was filed with delay of 2 years, and in some cases where there was no delay, the acquisition had been coerced. You know, these are the judgments I do rely upon.
Yes.
You know, as I earlier, you know, the Section 4, Section 6, and without giving opportunity, should have been given to us under Section 5A. That has not been done by the state government. You know, I do see, in spite of filed affidavit of service that I've served upon Mr. Chondikar at the time, and again, they are not appearing in the matter.
Or maybe we can start from HIDCO. We can start hearing HIDCO.
Run,
the records, Lordship, aligned with the LA collector, and on behalf of the LA collector, Mr. Dey is appearing. Lordship, he is the custodian of all the records. Lordship, I'll inform also, let Mr. Bhattacharya inform him again.
Why again?
Time and again, even in road.
Not necessary to inform him again. I will fix a date for hearing.
Usually, Mr. Dey always appearing in the court, always. Never.
Yes. Even by which part?
Whatever maybe, I am fixing a date for hearing.
But question does state and even to the extent no affidavit in opposition has been filed by state. Time and again, at least 5 times, umpteen times. Before Justice Josh and Gupta, before Justice Portonayak.
We can proceed, no issue. 2003, writ petition is pending since 2003.
Rightly
so. I have to dispose of. So today you complete your argument.
First, second, I have to say something. Second one. It is I have to beat your time notice. It will take only 10 to 15 minutes. As a whole, both these matters, the principle is the same.
But what is their different fact in second matter?
Same different facts. Some of the papers I have seen, my lord. Here of affidavit in opposition has been filed by respondent number 8.
Okay.
And the that BG press concern, and it would be evident that somewhere the requiring authority in the affidavit have stated that out of 277 plots, only 27, somewhere 29, somewhere 27 has been practically that they have used. Although nothing has been done, and still now, but I don't know. I cannot. I'm asking myself. As we go out of court, if those land is given to us, given to writ petitioners, I'll mention some tag number, plot number, Khatiyar number. Next day. That's why it will take it's a voluminous cheap. I was under the impression state government would say something, and
No.
state government is vital party here.
If they are not ready today, so we can proceed. So this matter, that is WPA 2259, is the first matter.
First matter.
So I am concluding that, and 1559.
15591.
One is the second matter.
Second.
You argue on that point on the second matter. Next, please take down. Argument on behalf of the petitioner in respect of 2259/2003 concludes. Petitioner shall argue in respect of writ petition WPA 15591 of 2003 in the next day. Let the matter appear in the legal.
Okay, thank you.
27th at 2 p.m.
27.
27th of August at 2 p.m.
27th.
August. Next matter.
Affidavit of service filed on behalf of the petitioner be taken on record despite service. None appears on behalf of the state respondent. Okay.
Matter is partly
Appear on behalf of the 8.
27.
Matter is part.
Both the matter. Both the matter part.
Both the matter part. I have taken both the matter together.
Your lordships, the allegation raised by
Let him conclude the second matter. Thereafter, I will hear.
my learned friend raised such contention with regard to this non-completion of the acquisition for a good number of plots. That is why, lordship, the entire records, lordship, of the LA collector regarding this acquisition posting is very much vital, lordship. And lordship, the appearance of learned advocate, government additional advocate, lordship, is record, lordship, and he will appear, lordship. Certainly he will appear. Anyway, he have been.
He informed.
Twice I have been informed.
27 is the date.
Lordship,
Petitioner has served.
lordship, without section 4 invocation, section 6 invocation, there is no scope to acquire the land. There is no scope, lordship. I believe, lordship, all things have been done, lordship, that have not been come within.
Actually, requiring authority, I mean, HITCO is a favored child of state.
Not favored. It's
That's a favored child.
it's
She
a
has been given everything.
not favored child. It has no profit. It's a government company, not favored child, not the like Tata Birla and others. Not that. Not that.
Okay. Call the next matter.
Much obliged.
Madam, I am appearing for the state. Madam, I am for the state matter. I am led by Mr. Papan Dr. Learned Senior Advocate. Let my learned friend start.
File করেন। ঠিক আছে? ফাইল করেন। করেছি তো। The subject matter of challenge in the proceedings is the order of suspension
Yes.
issued against the fair price shop dealer, who is the petitioner before your lordship. Your lordship, kindly turn to page 27 of my writ petition. The license. The first line of page 27, the fair price shop license.
Yes.
But kindly read, subject to the provisions of the West Bengal urban public distribution system. Your lordship knows there are two control orders. Although under 2024 targeted public distribution system, there are only control order. So for the 2013 is control, one meant for rural areas and another for the urban areas. Rural areas have been notified on 8th of August 2013, and so far the urban is concerned 12th of August 2013. But this is meant for urban areas. License has been granted to me. And kindly see next page, who is the issuing authority? Rationing officer, Basberia. There is a. Now you will also kindly come to page 32. My specific case is that I have applied for using of a separate godown in addition to my normal godown. That will appear from page 32. This is the application addressing to the rationing officer. I'm reading my Bengali letter. আপনার অবগতির জন্য ফেয়ার প্রাইস শপ নাম্বার 100 এবং অবতরণ বিভাগ স্বল্প পরিসর হওয়ার কারণে অতিরিক্ত বরাদ্দকৃত রেশন দ্রব্যাদি সংযোজন সম্ভব নয়। তাই উক্ত অতিরিক্ত সামগ্রী মজুদের জন্য সন্দেশকারী বাঁশবাড়িয়াতে অবস্থিত একটি গুদাম ঘরের ব্যবস্থা করা হয়েছে। উক্ত গোদাম ঘরের মালিকের সম্বন্ধে চূড়ান্ত পত্রের সাথে জুড়ে দেওয়া হলো। ওপরে উল্লেখিত ঘরটি আন্তরিকভাবে চূড়ান্ত বাধিত করিবেন। After this letter, a list has been prepared by the rationing officer of all the persons who have applied for separate godown, rather the additional godown, which will appear from page 33. Kindly see the reference number, rationing officer so-and-so, addressing to the joint director of rationing, who is the higher authority. Enclosed, please find here with application along with supporting papers of the following owner, Inspector Sub-Officer of the Fair Price Shop, of so-and-so. Kindly come to my serial number 12. Secretary, Basberia, Kamarpara Cooperative Society Limited, serial number 12. My specific case is that has been allowed. The document which I have annexed is not so legible at page 34. I shall show from my learned senior friend's affidavit. And the list has also been enclosed there at page 36, serial number 14. This permission has been granted to all the dealers who have applied for using for the additional godown. Page 4, serial number 14 at page 36. The address of the new godown has been given, Khamarpara Cooperative Society. Now, your lordship, kindly take up the opposition which has been filed by my learned senior friend on behalf of the state. Some documents which I have also annexed but it's not legible, I shall place before your lordship from the affidavit affirmed by the state, page 26 of the affidavit in opposition.
Yes.
Plus, this is the show cause notice issued by the rationing officer. Kindly take up. See the date, my lord, top right hand side, 27th of March 2024. Show cause notice addressing to the Secretary, Basberia, Khamarpara Cooperative Society Limited. Subject show cause notice. This is to inform you that the inspection under reference the following irregularities have been found. But pausing for a moment, this inquiry report has never been supplied to me. This is the admitted position. A shortage of 86.35 quintals of public distribution system rice, 32.53 quintals of public distribution system wheat, and 0.34 quintals of PDS sugar was detected at the time of inspection. Number of category-wise tax beneficiary list was not displayed. Scale cum rate board was not properly displayed. categorized opening stock of the day was not displayed. Sample boxes containing subsidized food grains was not displayed. Page 26, opposition. The food grains found in the godown was stored in the unhygienic manner. Then Marat, kindly read. It prima facie appears that you have contravened the conditions stipulated in para 4, 5, 6, 7, A, 13 of the clause 27 of the West Bengal Public Distribution System Maintenance Control Order. I am not governed. And Controller 2013, West Bengal Ordinary Public Distribution Maintenance Controller 2013. Hence, you are directed to show cause in writing within 7 days from the date of receipt of this notice as to why suitable action will not be taken against you in terms of para 24 of the said control order. Said control order. Above that, both the control order has been mentioned with the clauses. Now, of the said control order failing within ex parte decision will be taken. But before my lordship proceed further with the matter, 2013. Kindly take up the book so far the rural control order is concerned and the urban. First, your lordship kindly take up page 1.24 clause 24. এখানে পাবেন রামদার কাছে বই একটা আনবে না সাতখানা বই আছে
এই বইগুলো সব
the blue book এটা আরবান এটা রুরাল রুরাল একটা নীল বই নেই তো এখানে
2013
But kindly come to page 1.24.
One point
24.
24. Yes.
But kindly see the last line of page 26 says that date of receipt of this notice as to why suitable action will not be taken against you in terms of para 24 of the state control order. Page 26. But this is rural control order. Or to take action against the licensee for committing irregularities. I am not governed by the control order of rural control order. Now you will also kindly take up page 2.25. Now it starts from page 2.3.
Two point
2.5. Clause 24.
Yes.
This is clause 24 of the kindly read matter top West Bengal Urban Public Distribution System Maintenance and Control Order 2013. So according to them, they are proceeding against me under clause 24 of the Urban Control Order 2013, which control order, what says my lord, kindly see clause 24. Submission of indents by wholesalers. I am not a wholesaler. Every wholesaler shall submit duly Indian information. They have invoked this provision of law at the time of issuance of the show cause notice. Kindly read, my lord, page 24, 26. Last two lines. The date of receipt of this notice as to why suitable action will not be taken against you in terms of para 24 of the said control order, failing which the ex parte decision may be taken against you. Now, you will also kindly see the sub clauses of 4, 5, 6, and 7 of this. Kindly read, my lord, page 1.2.3.
Yes.
The clause which has been relied on 4, 5, 6, 7 that will appear page 2.11. Urban control order, because I am license holder under the urban control order. Or kindly see issue of ration card. Possibly this is not at all issue so far as focus is concerned. 5, appeal against refusal of ration card. 6, power of the state government to make addition or alteration or amendment of refusal. 7, validity of ration card. There is no subclauses in under 7A. Kindly read my 13, which has been invoked. Change of address, age, name, surname, head of the family in ration card. My license has been suspended, my livelihood has been taken away. In a mechanical manner, this process has been invoked at the time of or issuance of order of suspension. But this is not a service matter. I will not get any subsistence allowance. My entire job, entire service has been gone. Entire livelihood. Now you will also kindly turn the page. Not only show cause notice, kindly read. I gave a detailed reply at page 27. The first paragraph I have quoted the show cause notice. Kindly come to the second paragraph. Sentence starts. Moreover, madam. Moreover, madam, we also solicit your kind attention to the another fact regarding shortage of stocks that due to wrong uploading of stocks in the EPOS machine by the Food and Supplies Department and getting different allotment of stocks from the wholesalers. In present situation, a big discrepancy of stocks has been between the EPOS physical stocks in maximum fair price shops, including mine. For that, an order of the Additional Secretary, Food and Supplies Department, Government of West Bengal, under memo number so dated 9 June 2022. Can you take note of this? Page 27, opposition.
Yes.
Well, kindly read. Which copies to all concern of the department, including your good self, whereas it has been clearly indicated that in view of the anomalies of figures in the EPOS machines and the stock register of the shop, physical verification of stocks in the fair price shop should be kept suspended since the anomalies are clarified by IT cell of the department. Well, what happened at the time of initial introduction of the EPOS machine, there was huge anomalies. Your Lordship knows number of cases also filed so far the stocks are concerned. So Joint Secretary issued a circular instructing all the rationing officers and also the subdivisional controllers that during this tenure, you should not take any steps against any dealer for anomalies in the physical stock and the EPOS machine. Now kindly take my next paragraph. In another order issued by the Joint Secretary, Food and Supplies Department by memo dated 11/12/2023, where the department again clearly ordered to all concerned officers that without verification of stock balance, any type of show cause or penal action could not be taken by the department, copy enclosed, none of which was not followed in our case, whereas we have already informed the department through our federation regarding the so-and-so. These are my reply. I have categorically stated, enclosing there with both the memos. I am showing this document from their opposition. Now, your Lordship, kindly turn the page. The other queries which has been indicated in the show cause notice, opening stock, question of display of category book. I have categorically stated what was the real position on the date of inquiry. But so far the inquiry report is concerned, since has not been submitted to me, I was not aware about the fact when such inquiry even a personal hearing has been provided to me on 18th April 2024. Notice has been issued asking me to appear before the concerned rationing officer on 25th of April 2024.
Yes.
Now the questionnaires I have, which has been set up, they have annexed my lord. That is page 30. Date of personal hearing 24th of April 2024. And inspection was conducted in the fair price shop. So and so limited on so and so. But this report categorically have stated they have not denied ever been supplied to me. The entire basis proceedings has been drawn up against me on the basis of an inquiry. A report has been submitted by the inspecting personnel. Following the same show cause notice has been issued. Till today, I am not aware whether when the inquiry has been conducted, who conducted, what is the contents of that report.
Sorry for the interruption. This is not the subject matter of the present petition. This was the earlier, because he is a repeated offender. That's why this has been disclosed in our opposition. This show cause has come to an end with a amount of penalty imposed upon him. This is not the subject matter.
The next should know why when I am placing some documents, This has relevance so far the present show cause notice is concerned. I shall show to your lordship. Possibly there will be no further interaction. Malad, kindly see question, a shortage of rupees 35 quintals rice of PDS was detected at the time of on 7th March 2024. Then answer, my lord, guarantee of name so and so. Number of category-wise tax benefits list was not displayed. The beneficiary so and so. It could be so and so. But after this, no order has been passed. Why I am showing this document? After this hearing, these postings has not been dropped. No decision has been taken. I have not been intimated anything. This is the relevance so far the present show cause notice is concerned. Now, your lordship, kindly take up page, my lord, 32. This hearing has been taken place, your lordship, kindly see. (25th of April 2024), which will appear from the bottom, page 30. The signature of the inspector and the other
Date of
authorities.
personal hearing above. Date
Yes.
of personal hearing.
Now, your lordship, kindly turn the page. Kindly turn to page 32.
Yes.
To strengthen their case, they have annexed some documents. I am relying on the same. My learned senator is objecting to that you cannot show it. Kindly turn to page 32.
No, I've never said I cannot show. I said it has lost
Sir,
its
I am not
relevance
showing
because of
this.
the subsequent show cause which is under.
Then why you have annexed this?
I have a reason.
I don't have any
my
reason. You
turn.
have all reasons. Yes. Kindly turn to page 32. Read, my lord, from bottom, third paragraph. Before that, my lord, paragraph number 10. Complaint book was not found at the fry price shop. Moreover, the fry price shop has been a repeated offender. My lord, kindly take note of. So far, the first proceedings is concerned, show cause, reply, hearing, no decision. So that cannot be treated as offense. But in the second show cause notice, they are saying you are a repeated offender. Kindly take note of. Once again, I am reading, my lord. Complaint book was not found at the paragraph 10, my lord. Complaint book was not found at the price shop, so has been a repeated offender. How I become offender? You have not introduced any punishment. You have not dropped the, you have not taken final decision. You are treating me as offender, habitual offender. Next paragraph, next line. Show cause notice by memo dated so and so 17th March 2024. My lord, this I have shown to your lordship. Kindly turn to my lord the show cause notice first. At page, my lord, 26. Kindly see the date. This has the relevancy. Page 26, the first show cause notice. Kindly see the date, 27th of March 2024.
Yes.
It has been provided due to so and so much. It has been issued by the previously due to shortage of stocks of food grains under the PDS along with other irregularities. This time also the same offense were repeated by the fair price shop dealer. No improvement has been noted. Again, I am repeating, no punishment, not fine, anything has been done. Even I have not been warned. Next paragraph. It prima facie appears that you have contravened the conditions stipulated in para 1, 4A, 5, 6, 10, 11, 12, 13, 17 under clause 26 of the West Bengal Public Distribution System. Kindly take note of. Well, my livelihood is involved. I am a public fair price shop owner. My entire license business is being governed and controlled under a particular control order. Provisions are also different. Relying on a provisions of a control order which is not applicable to me, you have again issued a show cause notice. Totally mechanical approach of control order 2000, urban control order 2013. Hence, you are directed to show cause within 7 days from the date of receipt of this notice as to why suitable action will not be taken against you in terms of para 24 and 29 of the said control order. Which control order? You have mentioned some clauses of rural control order. Then stroke oblique urban control order. Then 24 oblique 29 of the said control order. Is it a joke? Kindly read my lord 5, 6, 10, 11, 13, 17 of the 26 control order. Kindly take note of my lord once again. What rural control order says. That will appear from page 1.11, which they have relied on. 1.1145, 1.12. Again, I am reading one. You have contravened the condition of stipulated in para 1, 4A, G, 5, 6, 10, 11, 12, 13, 17 under clause 26 of the West Bengal Public Distribution, not urban. Clause 1, 4A. There is no, kindly come to my note 4A. Any person or any family having no ration card anywhere may apply to the inspection.
Procedure for issue ration card.
Yes. Is it any charge? 5.
Appeal against refusal of
Appeal against the refusal of ration card.
all of ration cards.
7. Surrender of ration card. Is it not a joke? Again, I am repeating, this is not a service matter. No substances allowance. Livelihood. Not only me, my employees, my family members. Then kindly come to Malar, clause 26. Engagement of distributor. At page Malar 1.25. You are invoking rural control order, clause 26, at the time of issuance of show cause notice, which says how and which manner a distributor shall be engaged. I am a fry price shop dealer.
Yes.
West Bengal Food and Supply Services. They will kindly turn to 24 and 29. 24 part to take action against issuing license. If you also kindly take 29. At page 1.30. Duties and responsibility of a distributor. These are the charge. Invoking these provisions, second show cause notice has been issued, saying that you are repeated offender, although in respect of the previous charges, no punishment, nothing has been imposed upon me. This is the initiation of proceedings. My specific case is that this order of this letter of show cause is not sustainable in the eye of law. And if it goes, all subsequent steps also goes. This is a basic principle. Foundation goes, superstructure falls automatically. How can I give reply to this? Though adamant an FIR has been lodged against me at page 33. I also obtained bail. I am not going through that. Now, your lordship, kindly see another show cause notice, page 35. This has been issued on 26th of June 2024. During pendency of the previous two show cause notices. I can say two because none of them has been concluded. Kindly see the date of inspection, 4th June 2024. According to them, inspection has been conducted. I have no knowledge. No copy has ever been given to me. They have not denied the same. And date of issuance of the show cause notice, 26th June 2024. Inquiry 4th June. Kindly turn my lord, page my lord 32 once again.
Yes.
Kindly turn my lord, page 32 also. This has been issued. Second show cause 11th June. Inquiry 6th June. So 6th June inquiry show cause prior to the subsequent thereto. Kindly take note of. Page 32 says 6th June 2024 inspection has been conducted and show cause notice has been issued on 11th June. Have you also got?
Yes.
Kindly turn page 35. 4th June inquiry has been conducted prior to that.
14th June. 1/4.
Is it 14th? And show cause notice. I am sorry, my lord. My document is not. Anyhow, my lord, during pendency of the previous show cause notice, on 26th June, another show cause notice.
Yes.
Now kindly read show cause notice. That proceedings has not been dropped or allowed. This is to inform you that in that an inspection under reference the following irregularities have been found. Matlab, this report has also not been handed over to me. 3 inquiry, 3 show cause notices, none of the inquiry report has been ever been given to me. A shortage of so and so, no category of wise, sample footprints were not found, categorized appearing stock. It prima facie appears that you have contravened the provision of the para 4C6 of the West Bengal Public Distribution. Same. Relying and invoking provisions of a control order which has no manner of application so far my dealership is concerned. He is not an inspector, he is a rationing officer. He does not fall even, he cannot touch my lord West Bengal Public Distribution System entrance control order. A rationing officer is only concerned about the West Bengal Urban Public Distribution System control order. Now kindly see the next page. An inquiry has been conducted. And kindly read my lord once again, page 35. It prima facie appears that you have contravened the conditions stipulated in para 6 and so and so. Hence, you are directed to show cause in writing within 7 days from the date of receipt of this notice as to why suitable action will not be taken against you in terms of para 24. Malad, this is dated my lord 26 June 2024. Now you will also kindly take up my requisition. But this is not so legible. Oh, date of June. But this is June. Last annexure of my requisition, page 30. Page 38. The order of suspension.
11th June.
11th June 2024. Not so legible. কপি দিয়েছো তোমরা কি বলে পড়াই বলো তো এটা
ঠিক আছে এফিডেভিট উঠে গেছে
Your lordship copy is legible.
Page 38 is legible.
But kindly see top the show cause notice dated so and so has been relied on. And ultimate suspension, kindly see. Last but one paragraph. Then relying on clause 24 of the rural control order, my license has been suspended. There is no such provision under the urban control order. So far the suspension is concerned of a fair price shop dealer. I definitely, my learned senior friend will submit the quoting of wrong provisions does not vitiate the entire proceedings. This is not the first occasion. Thrice show cause notice has been issued, reply has been submitted, then suspension order has been issued. This is not a typographical mistake. For indefinite period, I have been suspended without pendency of any disciplinary proceeding. Because so far this part is concerned, your lordship kindly see, this is for indefinite period. There is no whisper till disposal of the proceedings.
Page 38.
Yes.
Of your writ petition is page 32 of AO.
32. Sorry, my lord, that is page. Right, my lord. I have seen, my lord. Now your lordship kindly read, my lord. This to inform you that in instance under reference to answer following regularities has been found, a shortage of so and so. First line your lordship kindly read. This is my lord dated 11th June 2024.
Yes.
This is to inform you that the inspection under reference, but is there any reference in the letter? Inspection under reference, the following irregularities have been found. Which inspection? Prior to that, 3 inspection has been conducted. This is dated 11th June 2024. I have shown to your lordship. March, 4th June and 6th June. No reference has been given. This is to inform you that in inspection under reference, which inspection? No report has been submitted to handed over to me. A shortage of so and so, so and so, so and so. Last part, third paragraph, it prima facie appears that you have contravened the conditions stipulated in para so and so under clause 26 of the control order. Again, my lord. Hence, you are directed to show cause in writing within 7 days from the date of receipt of this letter. Notice as to why suitable action will not be taken against you. Service area of the so and so cannot be maintained, and proceedings drawn against you may be vitiated by so and so is allowed to continue the so and so. Therefore, the interest of the public 24/1/29 of the said control order, your license is under suspension till further order. Now, this is under challenge before your lordship. Amongst all other grounds, first ground I have taken that invoking a provision having no nexus so far my dealership business is concerned. You have issued, conducted inquiry, issued show cause notice, imposed suspension upon me. My second contention is that, my lord, none of the inquiry report has been handed over to me. This is the admitted position. Thrice inquiry has been conducted. So far, the first two show cause is concerned, my lord, no result has been taken till today. My lord, I came before this honorable court, your lordship protected me by passing an interim order. The subdivisional, rather, my lord, the rationing officer so adamant, she did not comply with the court's order. Then I filed a contempt application. She was called for personally by your lordship, and then only interim order has been interim order has been complied with. Now I am running business. If you lordship kindly give me another time, another day, 5 to 10 minutes, because those two circulars I shall have to place before lordship. And two judgments, Mr. Agrawandhavade yesterday was also submitted two judgments. That judgments. So far the bias is concerned. Any day, 10 minutes I shall take. So far this circular is concerned, which restricted all the rationing officers, subdivisional controllers not to take any steps on the basis of the imposed machine. Any day.
Another day.
Argument on behalf of the petitioner continued. Let the matter appear in the second of September 2025 at 2 p.m.
No.
Further order. Second of September.
2nd of September. Interim order is going to be expired on 19th.
Interim order passed by this court on the earlier occasion is further extended till 19th of September. No.
2nd
17th
September.
of
মানে
September
মঙ্গলবার।
2025 or on further whichever is happening.
The matter to appear on 2nd September. Interim order till
17th.
Get much of this.
Till 17th.
17th.
2nd September at 2 o'clock.
Yes.
Interim order to continue.
17th.
17th.
I shall take only 10 to 15 minutes on that. To judgment I shall rely on and those both two circulars. Mohammad motion paragraph 40.
Last in aগে paragraph. ওই 3 মাস যেটা বলতে হয়ে যাবে প্যারাগ্রাফ 40
ওই কথা রামধারী রিপোর্ট হবে
কললি
সার্টিফিকেট দিতে হবে বলে রাম ফোন
The record kindly make it known to them.
I have already concluded my submission. They have
The state has already started.
Yes, my lord. Mr. Bandyopadhyay will cite some
That's
judgment,
true.
my lord.
I cannot stand on the way, but at the same time, this is a case, just 1 minute. A suspension order has been issued with punishment. Penalty huge amount. 7 crore.
Sir, more than 7 crores.
More than 7 crore.
Around 8 crores.
I filed the writ petition. A coordinate bench passed an interim order restraining the respondents from taking the money as penalty. So far, this part is concerned. My order of suspension has been issued for non-payment of penalty. But suspension part admittedly has not been stayed. Today, what is the situation? the cause of action of issuance of suspension order is for non-payment of penalty amount. Penalty amount has been stated. So question of deposition of money does not arise. So according to my understanding, suspension order automatically goes. This is my one leg of argument. And yesterday I have submitted before your lordship, there is a division bench judgment. You cannot put any distributor or dealer license under suspension more than 60 days. That is the statutory period for conclusion of the departmental postings. I'm handing over a copy of this judgment. I'm not pressing your lordship today because Mr. Bandopade, it will be taken up for hearing admittedly. Just your lordship, take note of this judgment. Paragraph 40 and 41. Division bench judgment. In 2006, it's online. It's no uncertain time, it says. Within statutory period, you have to conclude. If not, you can proceed, but suspension order should go. What is the bread and butter? Now, you also kindly come to the book, page 1.25, which no uncertain term says you have to conclude the proceedings within 60 days. Page 1.25, first paragraph, just sub paragraph, entire proceedings. Entire proceedings shall be concluded within 60 days from the date of issue of the show cause notice. If not, suspension order goes. Already more than 6 months has already expired. So this is the situation. You will also kindly take up this matter tomorrow. Since Mr. Bandopade, make it not today only. Anytime, because we are suffering for last 6 months. According to my understanding, my lord, staying the operation of the punishment.
6 months. 18 September.
18 September 2024, I have been suspended. Now you are near about 1 year. Yesterday also adjournment has been paid for. তোদের বই আছে প্রশ্ন একটা জাজমেন্ট দেখান কালকে they have already concluded their submission. Mr. Shishana Manager submitted before lordship that they will place one judgment and give me the citation prior to that, but no citation has been given to me.
This is running, okay. Okay, tomorrow.
Tomorrow, I'm grateful.
Not today.
I'm grateful. It will eliminate its position.
Yes. Call the list.
My lord, I came. Your lordship, the learned advocate general address your lordship on the maintainability point has been your lordship decided that yes, the writ petition can continue.
Yes.
Because we raised the point of maintainability on account of availing other arbitration. Lordship, kindly fix it, Mr. Learned advocate general is engaged in another matter.
So when can be heard it?
Lordship, next Wednesday at 2 p.m. subject to convenient to your Lordship,
Yes.
because I find that there are several other matters
Yes.
which are,
The Torodar is representing the petitioner.
yes.
Yes.
He told me to attend the hearing if they have argued the case.
Next Wednesday, it is 20th.
পুরোনো matter?
হ্যাঁ, আরে প্রদীপদার বলা হয়ে গেছে, কিশোর ভাই মেনটেনেবলি পয়েন্ট ছিল না?
Okay.
The old matter, according to
Let the matter appear in the list on 20th of August 2025
my lord, get through.
at 2 p.m.
Yes.
20,000.
The list.
But I am appealing for the petition, my lord. My lord, in this case, the petitioner has expired. Now, the wife of the petitioner has applied for the license on compulsory ground. Because wrongdoer has gone, wrongdone has been gone. The lordship will kindly, I am filing a supplementary affidavit. My lord will kindly come to paragraph 3. My lord, upon demise of the original lead petitioner, a family meeting was held wherein it was decided that Kalpana Maji, being his widow, should make application for the concerned authority for grant of API dealership license in her favor on compulsory ground in terms of the provisions of the West Bengal targeted PDS control. My lord, accordingly, the application was made on 21st April 2025 within the statutory period. Now, my lord, the SCFS issued a memo dated 24th April 2025 informing Kalpana Manji that her application cannot be processed because the matter of termination of license of a deceased dealer is sub judice. Now, my lord, termination of license has lost its force upon demise of the original lead petitioner. Since the original lead petitioner died and since there is a provision for appointment of the family members on compassionate ground under the statute, the SCFS has arbitrarily and illegally issued the memo dated 24th April 2025. Well, this court has repeatedly held that the responsibility of the living representatives of a wrongdoer for an alleged act must die with the wrongdoer himself. And the family members cannot inherit the sin of the deceased wrongdoer, and as to the application of Kalpana Maji cannot be kept pending in the garb of matter being sub judice. Well, this is my submission for your lordship, my lord. In this regard, my lord, a coordinate bench of this honorable court, and I am placing a judgment, my lord. Yes. My lord, kindly come to page 3.
Yes.
I have considered, second paragraph, my lord, I am saying. I have considered the submission made by the learned advocates appearing for the respective parties, and I have considered the materials on record. In my opinion, the responsibility of the living representatives of a wrongdoer for an alleged act must die with the wrongdoer himself. In the instant case for the alleged suppression of fact by Muhammad Ibrahim, who had already expired, his heirs cannot be deprived of the right to be considered for grant of license on compulsory ground. Accordingly, I direct the read petition number 1 widow of such and such to make an application for grant of license on compulsory ground within 4 weeks. There was liberty was granted. Here, my lord, application has already been made in this case. My lord, your lordship has also held in a judgment of Avijit Karmodak recently that, my lord, I am speaking that. Only one line, my lord. Your lordship has held, my lord. Only this line, your lordship, my lord. Here was also the case that the father was guilty of certain acts in passing paragraph 19, my lord. In passing, the region of the respondent authority also opined that as the previous conduct of the business of the district distributor had polluted the reputation of the IOCL, thus the petitioner cannot be allowed to run the business. The action of the respondent authority reminded me a story of Hitopadesh, where lion tried to kill a deer with allegation that predecessor of said deer had polluted the stream. In this particular case, the respondent authority illegally denied petitioner a notion which was already deprecated by this court in the earlier litigation. Under the above, I am give my lord. So it is a similar case where the petitioner had died, his wife has made application for compassionate appointment, and my lord, I am just paying for disposing of this writ petition by directing.
We have not received the copy of the supplementary.
ठीक बयान है मुझे receipt है. Here is the supplementary receipt.
So Swadesh Maji is the original petitioner
My lord, original petitioner.
who expired.
Who expired, and his legal heirs has been substituted, my lord.
Legal heirs has been substituted.
Now the legal heir number 1, Kalpana Maji, has made application, which has been kept pending for the final determination of the license. But that question is not now available to the sub-divisional control, my lord.
Whatever may be, I am taking the supplementary today.
My lord.
You take instruction. Supplementary affidavit filed on behalf of the petitioner be taken on record. Supplementary affidavit demonstrate subsequent fact concerning the said FPS. Respondent authority is directed to take instruction from the department and apprise this court on the adjourned date. This is the matter under the same heading on 3rd of September.
My lord, can it be expedited because the lady is without vocation of life, my lord. Any day it will not be.
Before that, I have fixed 2, 3, 4 matters like that.
Anyway, my lord, I am leaving to your lordship, my lord. I can't say.
Okay, 3rd, you come. 3rd is the first matter. I do.
My lord, 3rd, my deeply obliged.
Preventing to 27 are same matters. I am in item number 26. Mr. Bandhopadhyay has started his argument. Report number 17.
Mr. Suman Sengupta was there for the state.
Yes, you also recollect, this is that matter, my lord, where we challenge.
I understand.
Yes.
I understand.
The spending for a long period because the appellate authority, the appellate, lower appellate court, my lord, they had, learned judge was in our favor all through in the order. But they, my lord, it was remanded back to the, my lord, collector, which is not permissible. That is our challenge because now the goods, the wheat have been probably consumed. We are only entitled for refund of the price. That is as per law. Can I continue?
Where is Mr. Sengupta?
Learned advocate Suman Sengupta is here, but he's having difficulty in making submissions. He is having difficulty in making submissions, my lord. he instructed me to that we will be filing written notes of argument.
No, let them finish first. They have not finished yet.
No, I have not finished.
It will take some time.
I have started only, my lord. I had shown your lordship that it was initially detained by the customs authorities. Probably your lordship
I know
remember.
that. I know that.
আগের দিন ওরা নোট নিচ্ছিল যশোর বলাতে আজকে নোট নেই লাস্ট অকেশন
Let them
because the
take
arrangement
note.
they will take note because there are numbers of
Yes,
advocates.
what is your instruction?
I can take notes.
Whether Mr. Sengupta reached to this court today?
Yes, my lord, he is in court.
Ritesh আছে मतलब my Ritesh is also there.
Number of
He-
advocates.
Take note. He will take note because last occasion he took notes for all. Yes, right.
What is your prayer in the writ petition? I know the entire fact.
Yes. My lord, my prayer you also will find from page 28.
Recording at paragraph 101.
101 to 104. That portion, my lord, the additional district judge remanded. Otherwise, my lord, he held that the confiscation order is absolutely bad. I should start with that order, my lord. It narrates the entire facts.
If not possible to pay the petitioner current market price of the wheat.
Yes.
Question.
That is the, my lord, as per the provision. That is also, my lord, as per the price for the my lord, procurement price. The order starts at page 168.
Pradip Kumar Adhikari.
Sorry, my lord, 173.
Where is the portion order?
The impugned.
Impugned 10.
101 to 104. Page 207, you also will find the ordering portion. Page 207.
Yes.
97 that appeal be the same is allowed to contest at the cost of rupees. Impugned order passed by the subdivisional officer Bosirat is hereby set aside. Then, Mother 101. The subdivisional officer Bosirat is redirected to readmit the case under its original number in the procedure and determine the case appraised in compliance with the mandates of the Honorable High Court's order. It is certain, sir. Subdivisional officer Bosirat is directed to dispose of the confiscation in accordance with law after giving opportunity of leading evidence, both oral, documentary, or the materials already praised during confiscation proceedings, subject to all just exceptions, be considered after remand. The subdivisional magistrate Bosirat is further directed to furnish the applicant free of cost copies of all seizure lists and other relevant documents relied on by the prosecution respondent before proceeding with the confiscation proceeding. Well, the two findings, if you kindly come.
Now, what is the about direction of this court? MAT.
Is the MAT, my lord, that is, you recollect, initially the magistrate straightway directed for confiscation, which is not permissible under law. Now we challenge that before the Writ Court only passed directions for affidavit, then there was an appeal. The appeal court said that it cannot be done. They set aside and said that you should take initiate the confiscation proceeding in accordance with law. That is the order. And the appeal court only reiterated the provisions of the my lord, Essential Commodities Act. How it is to be done, 6B notice, in what circumstances confiscation, that was the direction.
Okay.
I'm just giving the finding. Because most major part of the judgment deals with the resolution at that time, my lord, before the Bosirat court, which boycotted the court of the learned additional district judge. But kindly take 197, decision with reasons. Adil 197.
Yes.
This is a confiscation proceeding under Section 6A, read with Section 6B of the Essential Commodities Act 1955, initiated by the subdivision authority before perambulating to separate the grain from the chaff by the process dispassionate judicial scrutiny. Hearing in mind the facts and circumstances of the case, let us look at the provisions relating to the confiscations of the essential commodities as enumerated under Section 6A and 6B of the AC Act. What are the 6A and 6B quoted? Now, kindly, I am just taking this opportunity to read 6A, where any essential commodity is seized in pursuance of an order made under Section 3 in relation thereto. A report of such seizure shall, without unreasonable delay, be made to the collector to the district or presidency town in which such essential commodity is seized, and whether or not a prosecution is instituted for contravention of such order, the collector may, if he thinks fit, so to do, direct essential commodity so seized to be produced for inspection before him, and if he is satisfied that there has been contravention of the order, may order confiscation of the essential commodities, any package covering or receptacle in which such essential commodity is found, any animal, vehicle, vessel, or other conveyance used in carrying such essential commodity. So there are two essential conditions. One is the allegation should be there that there was a violations of a control order. Violation of an order issued under Section 3. Your Lordship is aware that under Section 3 the control orders are issued.
Yes.
The power is vested with the central government, but subject to delegation, the state government can also. So not only violation, and it is to be seized in pursuance of that order. Not seizure under criminal procedure code or other provisions. It is to be seized in pursuance of that order. So two preconditions. One is violation of a control order, and that these essential commodities were seized in pursuance of that control order. But there are provisions under kerosene control order and other provisions. You will also find that the police, the competent authority has power to seize if any violation is detected. Now that gives rise to the confiscation proceeding. In the absence of both these two ingredients, the confiscation proceeding cannot lie. Let's kindly skip over page 198. No order confiscating any essential commodity, package, covering, or receptacle, animal, vehicle, conveyance shall be made under Section 6A unless the owner of such essential commodity, package, or covering, receptacle, animal, vehicle is or the person from whom it is seized is given a notice in writing informing him the grounds on which it is proposed to confiscate the essential commodities, and B is given an opportunity of making this representation in writing, is given an opportunity of being heard in the matter, then the second is show cause. That there must be a show cause informing the grounds. Now, what can be the grounds? See that I found this heat from your position, which is violation of this control order. Velocity, kindly keep in mind, after 1999, there is no control order regulating the purchase or storage of wheat in India.
Please.
Then, my lord, now page 199, the learned judge quoted the relevant portion of the order of the division bench.
Yes.
You will find from paragraph 66. The same thing, my lord, specifically, my lord, 6B was quoted. Now, issuance of show cause notice. From the confiscation proceeding, it transpired that on 2068, got it. On 22nd December, written show cause notice was issued to the present appellant, including other exporters and truck owners, drivers, disclosing the charge allegation against them for confiscation of the seized wheat as per section 6A of the EC Act. In this argument, the appellant has admitted acceptance of the show cause notice. So it is clear that the directions of the Honorable Court given in paragraph 16D of the judgment has been complied with. In the said show cause notice, SDO Barasat has categorically quoted directed to show cause why the seized wheat trucks will not be confiscated as per section 6A of the EC Act within 4th January 2000 and to attend hearing on 4th January. From the materials on record, it also transpired that the present appellant, including other exporters, have made representation in writing against the grounds of confiscation. So the direction of the Honorable Court contained in paragraph 16E has also been complied with by the confiscating authority. The case record reveals that from 4th January 2021, daily opportunity of being heard was given to the appellant, including other exporters and truck owners, given on the final day of the hearing, passed orders on such and such, learned advocates on behalf of all the 17 exporters, also the truck drivers were present and all were heard by the SDO. Then, now before proceeding further, my lord, I just turn back to the show cause. Page 109. That is, my lord, after the division bench order, show cause was given. As you also got it, page 109. Whereas a good quantum of wheat packed in gunny bags bearing marks and numbers of FCI, Government of India, Government of Punjab loaded in trucks which were stood in Gojadanga Customs Station, Bosirat, for proceeding towards Bangladesh for export, wheat has been seized by the Bosirat police station dated on 23rd October 2020. Only 7 gunny bags were seized on 23rd October. And whereas the investigation officer of the police authority has submitted prayer for confiscation of the seized wheat of the trucks which are being used for carrying alleged wheat as per section 6A of the on the following charges. Now kindly see the charges. Most of the challans being submitted by the exporters are likely to be fake, forged, and demands thorough investigation. The cultivation of wheat is stopped in West Bengal for the last 2-3 years. So the availability of the local wheat in West Bengal is quite impossible. The exporters were exporting seized wheat at the price less than minimum support price, which is contravention to the order under section 3 of the AC Act. There is no order, take it from me or let them produce any order, which specifies any MSP, minimum support price, and that it constitutes a violation if any export or purchase made below MSP. There is no such order. And there is no such order in existence. The most of the seized gunny bags were found stitched by machine, which is normally found in case of PDS goods. Government and all these things are indicative of public distribution system goods. And whereas the basis of the charges brought by the investigating officer, it primarily appears that the seized wheat are PDS goods and trucks were used to consign the PDS wheat in terms of export to Bangladesh illegally, and these kinds of business was conducted in contraventions of the order made under Section 3. Just pointing that will not serve the purpose. We should specify which order, because that is the condition precedent. That one has to specify which order and what provisions of any order I had violated, and whether these goods were seized in pursuance of that order or not. These are the two conditions, and you also will not find a single whisper of any control order. They said only order issued under Section 3.
Yes.
And that was the show cause. So when the very initiation of the confiscation proceedings was bad.
So what is the observation of the court?
Yes. Now again come back to Malad. I was in 197. No, sorry.
199.
199. No, 199 I have read already. 200. No inquiry, no evidence. 73. That is in the violation of natural justice, violation of 6B. Then
page 202.
202, paragraph 76. Here, in these confiscation proceedings, SDO Bosirat has neither made any inquiry nor taken evidence, either oral or documentary. Considering the seizure of 4 jute bags containing 50 kgs of wheat, in each bag seized, at the first instance and subsequent seizures of other gunny bags containing the alleged wheat, as noted as in the case diary by the investigating officer of SDO Bosirat, confiscation the same. It is categorically argued that no copies of any subsequent series of seizures were given to the appellant in spite of demand. From the file attached LCR, it appears that there is a seizure list of 23rd having seizure of 4 jute bags. As I said, Malad, the so-called says 23rd. There are other seizure lists around 175 in numbers prepared on 25th of October and 26th of October 2020, which were never given. In the impugned order, there is no whisper of supply of copies of subsequent seizure list to the appellant, so it is crystal clear that the confiscation proceeding suffers from serious legal. Then productions of seized essential commodity, that was also not done. 82. Then inspection of seized commodity. Now 204, that is satisfaction.
Yes.
May I read? The satisfaction of contravention of the order passed under Section 3 of the Act. In Kailash Prasad Yadav versus State of Jharkhand, the Honorable Appeals Court has been pleased to observe the violation of an order made under Section 3 of the Act, therefore, is a precondition of passing any order of confiscation. In Prakash Babu Raghuvanshi versus State of 2004-7, the Honorable Supreme Court has been pleased to lay down that though there is substance in the plea raised by the Learned Counsel for the state, yet for bringing an application under Section 7 of the Act, the essential requirement is an order, the violation of which is alleged. Unfortunately, neither before the trial court nor the High Court any efforts was made to place on record the order, the violation of which was alleged. In such and such, it was observed that a scheme like the one in hand is framed under Article 162 of the Constitution. That being so, it was necessary for the prosecution to place on record the order which, according to it, was the foundations for taking actions against the accused appellant. Section 7 refers to, I'll again come back to Section 7. Section 7 that was the prosecution 71A II. 718 says that if there is a violation of any control order, it will be an offense under 718.
Yes.
Exactly. Section 7 refers to contravention of any order made under Section C. It is essential for bringing any in application of Section 7 to show that some order has been made under Section C and the order has been contravened. Section 3 deals with powers to control production, supply, distribution of essential commodity. Exercise of such powers can be done by order. According to Section 2C, notified order means an order notified in the official gazette. And Section 6 says that order includes the direction issued. In the circumstance, without expressing opinion on the merits of the case, we remit the matter back to High Court to hear the matter after the party shall be permitted to place certain. Then Malad 88. In Dharmadev Jadov, it has been held that contravention of the provisions of an order issued under Section 3 of the AC Act is a condition precedent under Section 6A of the Act for confiscation of the seized essential commodity. Now, I'm skipping the next judgment, 99. Relying upon the above principles of, it is crystal clear that violation of an order made under Section 3 of the AC Act is a precondition for passing an order of confiscation. Here, in this case, in the impugned order, SDO Boshirat neither whispered anything about any control order made under Section 3 of the Act and violation of which was alleged in the confiscation proceeding, nor prosecution state has probably wrong illegally, has not placed on record any such order which, according to it, was the foundation for taking actions against the appellant and other exporters, a truck owner driver. The SDO Boshirat has not mentioned any specific ground of violation of any provisions of the control order, if the same at all exists. So, in the absence of any specific order made under Section 3 of the AC Act, and more so, without asserting any contravention of any provisions of the said order, confiscation of the essential commodity, the confiscation cannot be ordered. The foundation of the impugned order has not been erected in accordance with law.
Yes.
Now, you also will find from that if it is remanded to the SDO, it starts from the stage after the show cause, because otherwise no proceeding is there. So the learned judge said that the show cause doesn't disclose anything. The order doesn't disclose anything. How the remand can be made?
94.
Because the learned judge had came to a specific finding that there is no allegations of violation of any order, specific allegation. There is no ground. In such a situation, in my humble submission, state never preferred any challenge to this order. The learned judge remanded back. This remand is not permissible. In fact, learned judge accepted so far as this marking of jute bags. Well, we take the next 91. In his finding, the SDO Boshirat had mentioned that the wheat containing jute bags are having the marks and numbers of Government Haryana Food Corporation of India, and most of the seized gunny bags are found machine stitched, and all these indications are normally found in case of packing PDS goods. Referring to Rajiv Kumar Pandey versus State of Bihar, the Learned Counsel for the appellant has submitted that the findings of the SDO regarding the FCI in few gunny bags and matching stitching of bags are indicative towards the drainage of PDOC. It is a perfect example of conjecture and surmise, inasmuch as the appellant had duly produced evidence along with a reply to the show cause notice that gunny bags with FCI marks are abundantly available in the open market and are offered for sale. From the impugned order, it is revealed that the Boshirat has neither discussed about nor considered the said evidence as produced before the appellant. Rate of export price. In these findings, SDO Boshirat mentioned that the so-called challans, bills, invoices show such price at which wheat is being exported is lower than the control price, minimum support price, and this process is contravention. In this order, SDO Boshirat neither mentioned categorically the control price or minimum standard price, nor referred to the control order which fixes such control price or MSP. He has also not referred any specific provisions prohibiting purchase of wheat at a lower price than the control price or MSP. Absence of such particulars makes the impugned order baseless. Now, correction. Next, in the impugned order, SDO Bosirath has observed that it is not clear what is the source of those wheat from where the large quantum of wheat has been purchased. In straightway, exporter said that they had purchased from different sellers of wheat from different places like Habra, Barasat, Bosirath, Matsubushan, and also different places, other district, Malda, Birbhum, Murshidabad, Purbo Bardhaman, and from different districts of Bihar like Baksar, Begusarai, Madhubani, Kesar, Bhajpur, etc. It is further observed that the cultivation of wheat in a large scale is not found in recent years in West Bengal, and also the marketing of the wheat in open market and wholesale market in West Bengal is not so found in large scale. Usually, wheats are marketed in West Bengal from the state of Haryana, Punjab, and other northwest part of India, and other possibility of importing wheat to West Bengal by FCI to public distribution. However, wheat meant for ODS is not PDS is not legally allowed for marketing in open market by any private trader. Here again, SDO Bosirath has not mentioned any authenticated data of production of wheat in West Bengal and Bihar. How can he be certain that the cultivation of wheat in large scale is not found in West Bengal without having sourced the findings of the SDO? Bosirath are based on surmise and conjecture. On the above premises, it is crystal clear that on the basis of the finding arrived at SDO Bosirath, order of conflict could not have been passed. The impugned order cannot be sustained in law. The Honorable High Court. Now, the last portion, in the first portion, he said 16 ABC complied with by giving notice, by reply, hearing. Then see the order of the High Court has not been complied with. Now, today, what we stand for? Today, there is no challenge to this order by the state. They had accepted it. They had accepted with the findings. And I can show all these judgments. I am carrying this judgment. It clearly says that the violation of the control order and the seizure of the article under that control order is at the conditions precedent.
Yes.
If that conditions precedent are not there, the jurisdiction to initiate the confiscation proceeding was not there. So entire proceedings was void. It was a nullity. And by that manner, our wheat has been taken out without paying a single farthing. In fact, at that time, there are large scale of exports to Bangladesh and other countries. Even the ITC had exported wheat, all at our price, the same rate that was prevalent in the market.
So there is no such MSP like that.
No such MSP. In fact, wheat is decontrolled in 1999. I have got that decontrolling order. If you want to see 6, I can produce. It was decontrolled in 1999. So no question. If it is decontrolled, no question of prescribed any MSP. It is there only in respect of sugar and others. There is no MSP. The government procurement price is different. That is for the government to purchase. MSP is minimum support price. That is for purchase. Nothing to do with it. Is nothing to do with any control. There is no prohibition.
Very well.
Now, Caesar, you also will find, I'll show the Caesar list because only Caesar list was provided to us. Now, that I will show. Page 65, kindly take, sorry, page 66, 23rd. 66. Kindly take page 66.
Yes.
Two conditions, both are not satisfied. This Caesar, you will also find that this was seized not for violation, not under any control order. This was seized alleging commission of certain offences under the Indian Penal Code. This is the initial Caesar list. Kindly take the FIR also. This also doesn't disclose any commission of offence. Forget about adding the provisions of 7K on AII subsequently. The contents of the allegation. কোথায় দেখছিস তুই? FIR তার সঙ্গে contents নেই। contents you also will find first page 52, that was treated as written complaint, whereby it was forwarded to the OC by the customs authority, and this was the reproduction made in the show cause notice. The same thing has been narrated only on the basis of presumption. That is 52. Now the subsequent adding page 67.
Yes.
Sorry, 68. This was adding of 7(1) AII. It also doesn't disclose any order.
Violation of any control order.
Control order. And it also doesn't disclose that no, they are treating this seizure under that control order.
Okay.
Now I'll relying on certain judgment. Probably I have already shown you a lot of the relevant provisions. Now another interesting fact I'll show. You also will find from the confiscation order that there was no confiscation of the vehicles, but the goods have been confiscated. It cannot be. If it is said that you are carrying goods in violation of the any control order, the vehicle must be seized or it can only be released in lieu of fine. That is the provisions. I'll just show. Can you take kindly take 6A. Others got it. The second proviso.
Yes.
Second proviso, provided further that in case of any animal, vehicle, vessel, or other component used for the carriage of the goods of passengers for hire, the owner of such an vehicle shall be given an option to pay in lieu of its confiscation a fine not exceeding the market price of the date of the seizure of the essential one sought to be carried by such. But what the collector did, he released. Then Malad again take another. So what I said that when you are alleging that I had this wheat was Malad, there was contravention, even the presumption which the authority had made, then you cannot release the scrap. But the authority in the case, despite initiating confiscation proceedings, straightway released because the truck owners have come and shouted against them. They got afraid because these are all state managed. I'm not returning back to that time. Now kindly take 6C 2. That is one provision I have shown that only in lieu of fine it can be released. 2 is the what if they are unable to return, what they will pay. 6C2. Where an order under section 6A is modified or annulled by judicial authority, or where in a prosecution instituted for contraventions of the order in respect of which an order of confiscation has been made under section 6, the person concerned is acquitted. So there are two cases. One is confiscation order is annulled, and the criminal prosecution if the person concerned has been acquitted. And in either case, it is not possible for any reasons to return the essential commodities. Such persons shall, except as provided by subsection 3 of section 6A, be paid the price therefore, as if the essential commodity had been sold to the government with reasonable interest calculated from the date of seizure, and such price shall be determined in case of food grains, edible oilseed, edible soil in accordance with the provisions of section 3B of section 3, in case of sugar in accordance 3C, in case of any other essential commodity in accordance with the provisions of subsection 3 of section 3.
Yes.
So if now it is not possible because they are consumed, otherwise the wheat had become it has perished.
Okay.
Only judgments, I'll complete by 6:30. I place those judgments. Just give the citation. I have not placed. This was on the question of maintainability. The other judgments were on the questions of maintainability.
Yes.
So for the merit, I have not placed any judgment. Note করেছিলি না? Well, I'll just not 2007 5 SCC 769 that was referred to by the learned collector. That is the case of Kailash Prasad Jadhav. I'm just giving the paragraphs. That is paragraphs 5 and 10. Need not.
Kailash Prasad Jadhav.
Yes, Kailash Prasad Jadhav was referred to. Paragraphs, my lord, 5 and 10.
Yes.
Now, for the second judgment, my lord, just kindly take section 7 once, my lord, for a moment. Just section 7. If any person contravenes any order made under section 3, he shall be punishable in case of order made with reference to clauses, and to II in case of order made with imprisonment for a term which shall not be less than 3 months but may extend to 7 years. So 7(1)(a)(I) or (a)(II) is the penalty, the punishment. But it says that when there is a violation of any order issued under section 3. Now, on this aspect, the same provision is under section 6A for confiscation also. 2004 7 SCC 490, it's a very short judgment. আমার তোদের কাছে কপিগুলো আছে তো? Paragraphs 4 and 5. দে না কপিটা। Kindly read. Paragraphs 4 and 5.
Contravention of any order made under section 3.
It should be mentioned in the grounds. Then how can I reply?
Yes.
Then, my lord, single judge of this honorable court directed release when there is no violation. There is no my lord, violation of section 3. It's a one-page order reported at, my lord, 2011 SCC online Cal 1273. এটা আমাকে দে, এটা আমি পড়বো তো। নেই কোথাও, এই বাঞ্চেই থাকার কথা তো।
Yes.
The other judgment is, my lord, 2002 Criminal Law Journal 3978. Ashok Kumar Barnwal, that's the state of Bihar. Kindly take the same line. All paragraphs, my lord, all paragraphs, the small judgments, my lord, kindly take copy the nectar.
Ashok Barnwal.
ये दिलाम করতে 2000 2002 SCC online Jharkhand 383 আছে তোমার কাছে থাকা এটা কি হয় এটা আছে পেজ 15 প্যারাগ্রাফ এইটা করতে ঠিক আছে Right. Now, that is an interesting judgment. It says that most probably FCI markings नहीं পাচ্ছিস না প্রকাশ ডকুমেন্টস আছে ঠিক আছে আসছে না না খুব মোটা আমারটা এটা এত পাতলা কি করে এপিটোপিট করা
Yes.
Under order 41 if you see the appeal court can remand under specific circumstances. Under order 41 rule 23 deals with the remand, but no remand can be made mechanically when it is found by the court that certain evidences have not been considered. It requires to be considered again. On such situations, the remand can be made. But when the very initiation is bad, when it is absolutely without jurisdiction, in fact, I could have straightaway come to the writ court when this show-cause notice was issued. But because of the appellate's order, my lord, I waited. But when this show-cause notice was issued and the final order has been made, without preferring an appeal, I could have come because the proceeding itself was without jurisdiction.
Yes.
When it is without jurisdiction, my lord, no question of alternative remedy. And I'll just cite one judgment, 2021 11 SCC 2778 considered the provisions of the CPC. That in such a case also, when court should, my lord,
Remand.
26.1 to 26.6. Not a mechanical manner.
Okay, that's all.
That's all. Kindly consider that judgment. I'm not taking time. ওটা আছে। যেগুলো বললাম একটাই নেই, ওটা এসসিসি অনলাইনেও আছে। 2002 SCC online Jharkhand 383.
Please take down.
The only thing was the interim order is expiring on 22nd. More than 20 times the interim order has been extended. Let it be extended until further order because I have completed my submissions.
Very good. Argument on behalf of the petitioner concluded. Matter made further. Let the matter appear in the list on
তুমি অ্যাড করবে নাকি?
8th of September 2025 for argument on behalf of the state office. Interim order passed by this court is further extended till the disposal of the injured.
Fine, that will be. Separate order. Separate order.
Milord, may I, Milord?
নামগুলো দিয়ে দিচ্ছিস
for
Lord, may I permitted to mention, Lord, in
Now mentioning.
no, my lord, mentioning for my lord under compelling circumstances, my lord, due to some personal difficulty, my lord, I have to leave Kolkata today, my lord. So, my lord, my item is item 31, my lord. I have already informed the learned advocate for the petitioner, my lord, and the conducting advocate also, Mr. Huda also, my lord. I have intimated, my lord. So, kindly, my lord, I am praying accommodation for tomorrow, my lord.
Tomorrow.
Tomorrow, my lord, because, my lord, I have to leave for my native place, my lord, Uttar Dinajpur, my lord.
Tomorrow.
No, my lord, tomorrow I will not remain present, my lord.
Who is for the petitioner?
No, no, I'm not. He is for the petitioner.
Led by Mr.
I have also intimated Mr. Huda, my lord.
So what you want next week?
Next week, my lord.
Basically, keep it on Monday on the clock also, if possible. That's it.
Next week is not possible. September. Monday. 1. That's item 31. 1st September.
My lord, under extreme urgency, my lord, I am again mentioning, my lord, in the morning, my lord, mentioned item, my lord, item number
Extremely great.
23, my lord, I mentioned, my lord, in the morning, my lord, it's a review, my lord, under extreme urgency, my lord, I am praying, my lord, before your lordship, my lord, so that the matter can be, my lord, take, my lord, fixed in tomorrow, my lord, at the top, my lord. Otherwise, my lord, the difficulties, my lord, on 18th, the judgment decree, my lord, is to be passed, my lord, by the learned trial court. My revisional application, my lord, my contentions in order 22 rule 9, my lord, that the document, my lord, that the death certificate that they have produced, my lord, in order 22 rule 9, everything will be, my lord, infructuous.
কালকে কি আছে ডায়েরি? কটা? আর সকাল থেকে কি আছে? সাড়ে 10টা কি হয়? 10:52. Okay. Tomorrow Wednesday. কোনটা? এটা মুখার্জি? এই একটাই ম্যাটার আছে। তারপরে কোন ম্যাটার ধরবে? হুম? হ্যাঁ? 46 থেকে শুরু হবে তো? 4টে ম্যাটার আছে। তাই না? তাহলে কালকে স্পেশাল অ্যাসাইন ম্যাটার ফার্স্টে দিন। স্পেশাল অ্যাসাইন ম্যাটার ফার্স্টে দেবেন, তারপরে মেনশন ম্যাটার দেবেন, তারপরে কন্টেম্প ম্যাটার দেবেন। 50 থেকে শুরু করবেন। Tomorrow I will take up these matters. Especially assigned matter first.
My lord, grateful.
My lord, kindly take the matter tomorrow. I will take only 2 minutes.
Which matter?
67, item number 67.
67.
After 12. By 12, at 12 noon.
Item number 67.
Mousumi Khatun versus State of West Bengal.
What do you want?
Want just
No.
hearing. They have filed the affidavit of opposition. I have filed also reply as per the order of the honorable court.
Very good.
Kindly
70 amendment. Okay. After specially assigned matter, this matter will be taken up.
oblige.
67 টা কালকে মেনশন ম্যাটার।
Give the